Good afternoon, Ms. Rivers. How are you?
Good afternoon, Judge. How are you?
I'm doing well. Happy St. Patrick's Day.
It surely is. Happy St. Patrick's Day to you.
So we have a 2 o'clock calendar, which is 10 minutes away, so no one is late for that. But I think we were going to try to take a plea in, thank you, I brought my own out here, but I'll use this. We were going to try to take a plea in Mr. Harper's case. I see Mr. Harper on the screen, I think, and I know Ms. Wood has joined us. We also were going to take a plea for Mr. Kelly, who I'm guessing is going to be in booth 4 in 5N, but that booth is empty right now. So my thought is we try to take Mr. Harper's plea, and then as soon as we see Mr. Kelly, if that is going to be a plea, we take care of that. And then we will plow through our status conference calendar. Ms. Wood, are you ready to go?
Ready, Judge. Hello.
Hello, how are you?
I'm good. How are you?
I'm all right. Let me add you to the spotlight, and we will add, oops, come here. I believe that's Mr. Harper. Is that you, Mr. Harper? All right, if you would unmute yourself, please. I muted you a couple times just because I think there was a little background noise.
I'm sorry, sir.
Not a problem. Ms. Rivers, if you're ready, we're going to go forward with Mr. Harper's case.
Yes, I'm ready.
Great. This is case 22 SC 181980, State versus Michael Harper, who is charged with a drug offense and maybe some motor vehicle offenses and a misdemeanor I've never seen before that we'll work through. Mr. Jordan represents the state. Ms. Wood represents Mr. Harper. Mr. Harper, my understanding is that you're prepared to go forward with what we call a non-negotiated plea, which simply means you want to enter a guilty plea, but you and Ms. Wood haven't been able to reach a complete agreement with Mr. Jordan. So assuming I accept your plea, Ms. Wood is going to make one recommendation for a sentence for you, and Mr. Jordan is going to make a different recommendation. You'll have the ability to withdraw your plea if the sentence that I give you is more severe than what Ms. Wood asked for. And as a most basic example, if Ms. Wood asked for probation only, and I give you any jail time at all, 1 day, 1 minute, 1 year, you'd have a chance to reflect on that, to decide, you know what, no, thank you. I'd rather take my case to trial. And then we undo this like it never happened. The prosecution wouldn't be able to tell the jury, wow, this guy tried to plead guilty and then he got scared. No one would hear about that. But you might decide, you know, that's not what I was hoping to get, but it's better than going to trial and being found guilty and getting something worse. But you will have a chance to confer with Ms. Wood before you need to decide what you want to do. Does that make sense?
Yes, sir.
Okay. Mr. Jordan's going to put you under oath in just a moment. Once you're under oath, it's important that you answer all his questions and mine truthfully and completely. It's also important that if you've got any questions that you want to discuss privately with Ms. Wood, you let me know, and I can put the two of you into a breakout room where no one else can see or hear you. You can speak freely, and then you guys will pop out of that breakout room and can talk to me about whatever you need to talk about. Will you do that?
Yes, sir.
Excellent. Before we go any further, Mr. Kelly, if that's you, will you raise your right hand in booth 4? Excellent. We're going to take a plea in your case, I believe, right after we take this plea. So please stay where you are, okay? I can't hear you right now. I will make it so I can hear you, buddy. I got your thumbs up, so you stay there and we'll do your case next. So Mr. Jordan, when you're ready.
Thank you, Your Honor. Mr. Harper, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name?
My name is Michael Chad Harper,
And can you spell that, please?
Michael Chadharper.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
I'm 39 and I went to ninth grade in school.
Are you able to read, write, and understand the English language?
I don't know how to read, but I know how to understand.
Mr. Harper, we're not going to ask you to read anything during this conversation, but if anyone uses words or phrases that don't make sense to you, will you stop us?
Yes, sir.
Excuse me, and have us explain it in a different way?
Yes, sir.
Thank you.
Do you understand that you have been charged with the following offenses? Count 1 being possession of methamphetamine with intent to distribute. Count 2 being possession of drug-related objects. Count 3 being wrong way on a one-way street. And count 4 being driving with a suspended license.
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Lacey Wood, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with her services?
Yes, sir.
Ms. Wood, do you waive formal reading of the indictment?
So wave.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Harper's name?
So wave.
Mr. Harper, do you recall having been arrested on these charges?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Wood, do you know of any outstanding warrants related to these charges?
We do not.
Mr. Harper, has your attorney advised you the minimum and maximum sentence for each charge that you are pleading to?
Yes, sir.
And Your Honor, for count 1, possession of methamphetamine with intent to distribute, that is a minimum of 5 years and a maximum of 30. For each remaining count, since they are all misdemeanors, the minimum is 1 day and the maximum is 12 months in custody.
On the calendar, it also lists the misdemeanor I was referring to, which is request for ambulance service when not reasonably needed. But I'm assuming that was an NPGJ because I've got the indictment in front of me and it has exactly the 4 things you mentioned.
Yes, Your Honor.
Okay. I'm sad we're not going to learn about that one.
We may yet, Your Honor.
Okay.
Do you understand, Mr. Harper, that this is a blind plea or also called a non-negotiated plea, which means the state may still recommend a sentence to the court?
Yes, sir.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, sir.
Are you aware of the state's most previous offer, which, Your Honor, is on count 1? The state's recommendation is 6 to serve 6 months. All other counts, Your Honor, would be 12 months probation to run concurrent with count 1.
So your recommendation in this case will be, and is now, 6 years to serve 6 months balance probated.
That's correct, Your Honor. Mr. Harper, were you made aware of that most previous offer?
Yes, sir.
Do you understand that if you enter a non-negotiated plea, the judge has told you that you will have the right to withdraw that plea today? Is that correct, Your Honor?
Yes.
Yes. Do you understand that this is still a guilty plea, which is permanently recorded on your criminal history?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Are you currently on probation or parole?
No, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and finally, the ability to obtain employment?
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in the commission of a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
Mr. Harper, how do you plead to the charges of possession of methamphetamine with intent to distribute, possession of drug-related objects, driving the wrong way on a one-way street, and driving while license suspended?
Guilty.
And I apologize, Your Honor, I left out the indictment number. That indictment number is 22 SC 181980. And Mr. Harper, is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that for the felony charge, you have only 4 years from today to file a habeas corpus petition, and for the misdemeanor charges, you have only 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Ms. Wood, have you advised to Mr. Harper his deadlines for filing a direct appeal?
Yes.
Thank you, Your Honor. For a factual basis, on October 21st of 2021, an officer from the Hapeville Police Department initiated a traffic stop on a moped going the wrong way.
So I'm sorry to interrupt you. The indictment says December 17th, 21. Maybe it's a two-part story.
That's
But
what I got called.
I just want to make sure I'm hearing about the right info. It's not a material issue.
Your Honor, that may have been a clerical error in the summary for the case. I do see as well that the date that we had was December 17th of
Okay.
2021. So my apologies.
Anyway, we've got someone on a moped in Hapeville.
Yes, Your Honor. On
Okay.
December 17th of 2021, Mr. Harper was seen on a moped going the wrong way on Marina Street at Dogwood Avenue in Hapeville. Once stopped, the driver indicated his license was suspended and identified himself as Mr. Michael Harper. When Mr. Harper pulled out his wallet to show identification, he also pulled out a small plastic bag like those commonly used for drugs. The officer confirmed that Mr. Harper's license was suspended and proceeded to pat him down for weapons. In doing so, the officer felt something in Mr. Harper's right pocket that, based on the officer's experience, he believed to be a controlled substance. The officer removed the item from Mr. Harper's pocket and found a Ziploc bag containing a large amount of suspected methamphetamine. That methamphetamine was later tested and was confirmed to actually be methamphetamine. Mr. Harper advised that the suspected drugs would be sent for testing and he did advise that they were. He said, "I'm not going to lie to you, it's dope." Mr. Harper was then arrested for the offenses of possession of methamphetamine with intent to distribute, possession of drug-related objects, driving the wrong way on a one-way street, and driving with the license suspended. That concludes the factual basis, Your Honor.
All right. And your recommendation you've explained. I don't know. We do. Ms. Jackson is here. Hey, Ms. Jackson, good afternoon. Happy Friday.
Hello, Judge. How are you?
I'm well. What can you tell me about Mr. Harper's criminal history?
Is this Michael Harper, Your Honor?
Yes, ma'am.
The defendant has 34 cycles. The defendant's last arrest was May the 18th, 2022 in Hateville, Georgia, for driving without a valid license. There was no disposition for that arrest. The defendant does have prior felony convictions. This one in 2015 out of DeKalb County for possession of a firearm by a convicted felon. This one in 2013 out of Coweta County, Georgia for possession of Schedule III controlled substance. And there was one in 2011 for aggravated assault. And the defendant did receive first offender treatment in 2010 for possession of a firearm during commission of a felony and possession of methamphetamine. That case was sealed November the 22nd, 2017. The defendant does have misdemeanor convictions. This one in 2019 for driving without a valid license. And there was one in 2017 for driving without a valid license. And there was one in 2015 for driving while license suspended or revoked. And there was one in 2014 for theft by receiving stolen property. And one in 2013 for theft by taking. And one in 2005 for driving while license suspended or revoked. The defendant does have a history of failure to appears. There was one in 2019, one in 2018, one in 2015. Also, the defendant has a history of probation violations. There was one in 2020, and one in 2019, and one in 2017, and one in 2015. Nothing in addition, Your Honor.
Thank you so much. That was very thorough. Ms. Tucson, good afternoon. How are you?
Good afternoon. I'm well. How are you?
I am also well. Is Mr. Harper on active probation at this time?
No, not active probation. The last one ended in 2020.
Okay, great. And I have the repeat offender notice up, and it matches, of course, exactly what Ms. Jackson said. I've got the 5 convictions right there. Ms. Wood, tell me what you want to share about Mr. Harper and your recommendation.
Thank you, Judge. We will not squabble with the facts as reported by Mr. Jordan. Mr. Harper was completely forthcoming and cooperative on the body cameras, and he's been eager since I've had this case to reach resolution. He actually served 49 days on this. He was in from December 17th, 2021 until February 3rd, 2022 before making his bond. So we would ask for that credit. Our recommendation is just going to be 5 years probation to serve that 49 days credit for time served. He actually has a newborn child, so that is why we are hoping that the court would be inclined to give him a shot at probation. He also is self-employed. He does construction, brings houses for a living, and he's a lifelong Georgia resident. So he makes active work considered by the commission.
Okay. Mr. Harper, you have a new child, a boy or a girl?
A boy.
Okay. Is that your first child?
No, no, sir.
How many kids do you have?
3.
Okay. How old are your other 2 kids?
One's 17, one's 23 months old, and one's newborn.
Okay. So 17 years, 23 months, and then brand new.
Yes, sir.
Got it. Do any of the kids live with you right now?
No, sir. One does. Newborn does.
Okay. And are you the sole provider, or is your son's mom there as well?
I am. I take care of him.
Okay. What does his mom help?
No, sir.
Where is his mom?
I don't know.
How did he end up with you? Since he comes out of mom, how did he end up with you?
Well, she left the hospital, and I took him because she said she didn't want him.
Okay. Do you live alone or do you live with other people?
I live with my mama.
Okay. Does your mom help take care of your son also?
Yes, sir.
Does she work?
Yes, sir.
What does she do?
She can clean up houses.
Okay. And then you do construction work?
Yes, sir.
Got it. Anything you want to add to the situation, Mr. Harper?
No, sir.
All right. Well, Mr. Harper, I'm excited for you that you have a new child. The one that's 23 months, is that a boy or a girl?
A girl.
And does she live with her mom?
Yes.
Okay. And the 17-year-old, practically an adult, is that a boy or a girl?
A girl.
Does she live on her own or with her mom, or where's she?
With her mama.
And is that the same mom as the 23-month-old or different mom?
Different mom.
Okay. Are they both local so you can visit them?
Yes, sir.
Okay. All right. Well, Mr. Harper, you've been in and out of trouble for a while now. I'm sure that's frustrating for you. I bet it's particularly frustrating for your mom. I know it's frustrating for law enforcement. My guess is the folks in Hateville probably know you pretty well. And you're driving without a license a lot. And we need to figure out a way to get it to stop. I know you've got a newborn, and that may help you focus on things, but it's not your first kid. The one who is almost 2 years old, will be 2 years old next month, has been with you while you've actually racked up some of these arrests and misdemeanor convictions. Your last felony was a while ago. You had a gun. That would have been it is 6 years ago. But you're having trouble staying out of trouble. Any thoughts on how that might be different as you get older?
I'm staying out of trouble now for my newborn. They straight me all up.
Yeah. Okay. Well, here's what I'm going to do, Mr. Harper, because I'm hopeful that the newborn is going to help you out, but the one who's 2 years old, I don't know that she didn't keep you out of trouble in December of 21, and she would have been alive and well then. I am going to sentence you to some jail, but listen to the whole sentence, and then you and Ms. Wood can figure out what you want to do. So on count one, I am sentencing you to 5 years to serve 6 months. You'll get credit for the time you've already served, so it's going to be less than 6 months that you do. And then the balance will be on probation, so it's a little less probation than the state has recommended. And then for the other 3 counts, all the misdemeanors, I'm sentencing you to 6 months to serve on each of those, but they'll run concurrently with the first one. So it's an overall sentence of 6 months in custody. You've already done 49 days of that, followed by 4.5 years of probation. If you decide that that's what you want to do, and you and Ms. Wood can talk about it, I'll put you in that breakout room I described. You can let me know when is a good turn-in date. You don't need to come here today. That's not what we're talking about. But in a few weeks, you'd need to turn yourself in. Assuming you turn yourself in on that day, if we're going forward with this kind of sentence, rather than going to trial and rolling the dice to see what would happen, then that's the sentence I'd give you. If you decide not to show up on your sentencing date, it'll be something different, and I'll talk to you about that if you decide you want to go forward with what I've described. But I'm not comfortable that just probation is going to keep you safe and out of trouble and in a position to take care of your new boy, as well as your still pretty new daughter. And I know she doesn't live with you, but she needs you to be in her life. But having her around didn't keep you out of trouble in this case. And so you can maybe understand why I'm not super convinced that your little boy is going to keep you out of trouble. But I think the combination of your little boy and taking a time out may help focus you on working and being there for your family rather than doing some of this other stuff you've gotten mixed up in. Do you have any questions other than, hey, I want to talk with my lawyer, which you'll do in just a minute, about what I've just said?
Yes, sir. Can I ask you a question? How if I go to I'm in a drug program right now. Dr. Murray Medical.
Okay, what are you doing?
I'm taking classes for drugs and a urine test every month.
That's good. And how often do you go to class?
I go there every 2 weeks.
Okay. Well, I hope that's something you'll continue. In fact, I'm happy making that a condition of your probation, that you keep doing that. That kind of thing, I bet, is pretty helpful for what you're trying to do. Do you have any other questions?
I'm just trying to stay with my son, sir.
Okay. I want you to stay with your son, and your son's going to be right where you left him when you get back. And I want that to happen, but I've sort of explained my situation. What I'm going to do is have you and Ms. Wood talk a little bit, and then we'll talk as a group again before you have to make a decision, because you have the ability to say, no, thanks, Judge. I want to go to trial instead and see what happens there versus this. Like I promised you, you're going to have that conversation with Ms. Wood, and then we'll talk again. Okay.
Okay.
All right, Ms. Wood, I'm gonna move you guys to a breakout room.
Thank you.
You bet. And there you go. Okay, you guys come back when you're ready, please. Okay. Ms. Feely, do you represent Mr. Kelly?
No.
You don't. All right, Mr. Kelly, when we get Ms. Wood back, we're going to take your plea, okay? Let's turn then to our status calendar, and I'm happy to handle your cases. We need to handle your cases first. Mr. Shapiro, if you're here only for Fagerlin, that's off now.
Yes, Judge, also for DeMarcus Dixon.
Okay. All right, we'll get to that. We'll need Ms. Wood for that, but then we'll get you out of here. You two are the go for Monday, because I emailed you last night, I think. The Farrell case is off. So Tutman is what Judge Emerson will be doing on Monday morning. I'm assuming that's still a go.
I met with him yesterday. It's still a go.
Okay, great. I'll be in 1D Delta, and Monday is just jury selection, motions and limine, whatever you've got. But I was just in 1D. It looks good. It's big. It's ready for you. You're welcome. Well then, Ms. Feely, your first position is Keith Berry. Is Mr. Berry may be in custody. Ms. Nelson told me that folks were okay having a status conference without their clients.
That's fine.
Okay. And then are they both, let me look at the charges.
One of them was Mr. Whitenhour's.
Okay, but Ms. Willingham is on the call. Hey, Ms. Willingham,
Hi, Judge.
how are you?
I'm well, and you?
I am also well. Let's get you on the screen there. There we go. So let's talk about Mr. Berry, and let's start with Ms. Feely. You've got both his cases. Do you have discovery in both his cases?
I believe so, yes.
Okay. And I assume the case with Ms. Willingham is the one that is going to mostly drive things. I'm not saying that the facts are stronger, but the charges are more serious.
And he actually has one other case that's similar in nature as well.
That's on this calendar?
It's not listed as a position, but it's listed under number 6. The case number. 22 SC 182437.
437. Okay. Which is how we picked up the forgery. Got it. Let me look at, and so Ms. Willingham, do you have both those cases?
I just have the DV case. It is my understanding, but I do know that Ms. Feely did mention the forgery, and I'm happy to try and do a global resolution. It is my understanding that previously that was what ADA Whitenhour was doing. So I'm happy to still try and do that. I believe we emailed back and forth a little bit, but I'm not sure. I don't believe I got update from my last email.
Okay, I didn't ask my question well. Mr. Barry has 3 cases. One is the forgery, and Mr. Jordan will manage that, but I think that case will follow along. Mr. Barry has 2 family violence aggravated assault cases. There's one that's on the calendar that ends in 295, and there's another one that's listed on the calendar, but just in the notes section.
The 437.
Yes, ma'am.
I will handle that one as well.
Okay, so you got both those. All right. Ms. Feely, you've got discovery on all 3. Okay. In interacting with the prosecutors and Mr. Barry, are these cases something that are likely to resolve short of trial, or should we move them? I only have the 437 up on the screen. That's on a May calendar. Are these other 2 on the April calendar? I can find out. Let me just click this. 295 is, no, they're all on it's not published yet, but a May trial calendar. So all 3 are trending towards the May 8th trial calendar. That seems like a reasonable destination based on you having discovery, the nature of these offenses. Looks like there's an aggravated stalking in one of them, but Mr. Barry's having some issues with at least 1, if not 2 people close to him. And then there's the forgery. Any reason we shouldn't push towards the May 8th trial date?
That sounds perfect. I have an offer that we're going back and forth a little bit on that, but I think that's plenty of time.
Okay. You don't think there are any CP cases out there, just the 3 SC cases?
Pretty confident that these are the only 3.
Okay, excellent. Ms. Willingham, it sounds like Ms. Feely is good having this move towards that May 8th trial calendar. Certainly if it's resolved short of that, we ought to get Mr. Barry in here. He's been in jail not quite a year, but it's moving in that direction. Do you have anything in terms of discovery concerns or anything else I ought to know about, Ms. Willingham, concerning the 3 cases being ready for trial?
Yeah, I don't have any concerns in regards to the cases being ready for trial. No.
Okay, great. And Mr. Jordan, the forgery piece.
No concern, John.
No concern, since you're not really going to have to lift a finger on this anyway. Excellent. Got it. Okay. Well, Ms. Feely, I know you'll let Mr. Barry know we had this session, and as always, we're open for a plea whenever that's set up, but no one should be surprised when all 3 cases appear on the May trial calendar. Okay.
The other one is position 16, and it's with Mr. Tawanta Williams.
Well, I'm sorry, Judge, I didn't see that on the, but
All right,
I do see that now.
great. So let's do that. Is Mr. Williams here?
Yes.
Which one's Mr. Williams? There's Mr. Williams. Excellent. Okay. So let's talk about that one. And then I need to talk real briefly about Mr. Torre, and then you're free to go. Mr. Hiles, you're here. Do you have a case on here, or you want to talk about MAXX?
Oh, I tried to forget about him this afternoon, but I have James Robinson on here.
Okay.
We can.
We will. I need to, because Ms. Nelson told me you had a question about that, so I need to close the loop on that. Let's do Mr. Williams's status conference. So, do you have discovery in the case?
I have discovery, and we are well down the road of plea negotiations. I was hoping this would happen faster, but I have engaged an expert to evaluate Mr. Williams in mitigation. I've submitted for funding to be approved, and I've engaged with the expert. It just is now a matter of actually getting him in.
Timing. So Mr. Williams's case is on the April trial calendar. We've got lots of cases on there. So if we can't get to this because of the time constraints for the expert, I'll understand. But he is out on bond on a serious charge. So I'm just looking at the age of it, though. It looks like the arrest was from 3 years ago. So it would be good for everyone involved, alleged victim, Mr. Williams, his family, get some closure on it. Is April 12th going to be a stretch on the expert front? Or
Unfortunately, I think it would be, but I also don't think that this is going to resolve with the trial based on my discussions with Mr. Shapiro.
okay. So what should we do for its next stop? Should we say it's on I think the April calendar has already been published, so it's on there, but we've already been making some things are already coming off because of X or Y or Z. Should we be making a note that it couldn't be reached, but it really wouldn't be reached anyway? Do we keep it on there because hopefully we can take a plea off of it, or go to the May calendar?
I'm happy to leave it and just see if we can expedite this process. And if we can, I can let the court know. And
Okay, let's do it that way. Just let Ms. Nelson know. So your hope, Ms. Feely, is that the expert might narrow the gap or bring Mr. Shapiro closer in your direction if the expert evaluation heads in the way you think it will.
Right.
Okay, fair enough. Mr. Shapiro, any discovery issues or witness issues in Mr. Williams's case?
That states where, Judge.
Okay, let's leave it on the April calendar. Don't gear up for trial on that one, especially if you've got other cases on that calendar. But we'll keep it there. Mr. Williams, do you have any questions about what we've been talking about? Okay, Ms. Feely, you've got current information on Mr. Williams in terms of phone number, email, whatever? Good, okay. If anything changes, Mr. Williams, about how people track you down, you need to let Ms. Feely know, because she needs to be able to find you to keep working on the case, okay? All right, do you need Mr. Williams to stick around?
I'm going to speak with him in the hallway.
Okay, so if you'd stay, Ms. Feely's almost done. When she releases you, you're good to go. All right, did you have anything else, Ms. Feely?
I don't. I'm happy to stick around and help out if Ms. Wood needs me to.
Okay, we'll see. Let's talk about Mr. Torre real briefly. We've got what you or Ms. Robinson had said was, Patterson had said, was March 28th transport order, but before that could happen, there would need to be some disposition, whether it's a dead docket or not really a dead docket, need to be an all pros or a plea, which probably requires you, but you're going to be unavailable next week. The week after you'll be available, and that whole week is, well, it's only like one day before the 28th. What I don't want us to do is it took a long time to line up these resources. And if we've got this magic door of the 28th, we ought to get it. So I don't know if Ms. Primovic can help with this, or I guess it's a request from me to line up backup counsel if you're tied up in front of Judge Emerson, but the stars align with Mr. Torre.
That is exactly what's happened.
Okay.
Mr. Rick is going to be covering my cases on all the calendars.
Okay, I don't expect to call, and this has been my commitment to you and Mr. Shapiro and folks who are on the Emerson calendar. I won't be calling one of your cases to trial. This isn't that. This is a unique situation, guy who's been in custody for 2,300 days. We may be getting him out. We ought to, and I know you're going to be elsewhere, but if you've lined up backup, then we're all set. I just know I'm gonna have Ms. Nelson bugging as the 28th approaches.
So my understanding from her email was March 23rd was going to be the afternoon of the 23rd.
Sure, whatever she says is what's happening. I will be here. Mr. Jordan will be here. You won't, but I just want to make sure it's not Ms. Wood saying, I don't know, I'm not authorized to do this. So good, then that takes care of Mr. Torre, and we're gonna find out what's happening with Mr. Harper. Did you have anything else?
I do not.
All right, Mr. Shapiro, you have one with Ms. Wood also?
I do have.
Okay. All right, let's see if they're back. It doesn't look like it.
I'm back, but I don't see Mr. Harper back.
Oh, I can get him back. Are you back, Ms. Wood?
I'm back, Judge.
Okay, I'll go into the breakout room and see if I can fix that.
Thank you.
Sure. All right, he'll be popping out in 8 seconds. And then we'll do Mr. Kelly's plea right after that, because the jail has graciously let us borrow someone's Zoom booth spot. All right, he's back. Let me close that. And Ms. Wood, there we go. We got everyone on the screen. So Ms. Wood, did you and Mr. Harper have an opportunity to discuss his options?
Yes, sir.
Okay, I know he's not particularly excited by any of them. I respect that, but we are where we are given what he's been through and his situation. So does Mr. Harper want to move forward and get a reporting date, or does he want to withdraw his plea?
Judge, he does want to move forward and he is asking for if the court is inclined to give him a couple of weeks so that he can just make sure he has childcare lined up for the baby, but he is interested in accepting this and moving forward.
Okay, and I will certainly do that. Mr. Harper, today is a Friday. If I had you turn yourself in, as in come to my courtroom, like you were here yesterday or Wednesday, whenever it was, if I had you come on April 3rd, so that's 2 weeks and a weekend, does that give you and your mother enough time to try to make the arrangements you want to make?
I got an open defect case on 11th. I go to court on.
Say that again?
I got an open defects case on 11th of next month.
Okay.
I need to be in court for it.
Well, you obviously can't be if you are in custody. What is the is the defects about your son or your daughter?
It's about my son.
And not your 17-year-old son, but your brand new son.
Yes, sir.
What's his name? Just so I can use his name instead of saying your son.
Michael Chad Harper, Jr.
Okay. So Michael, Jr. What do you call him?
I call him Michael.
Michael. Well, I'll call him Michael too. So you are going to be in front of DFACS on the 11th to talk about what?
Talking about, and I won't get replacement, permanent placement.
Oh, whether he could be permanently placed with you.
Yes,
Okay. Is that something you are hoping to have happen?
yes.
Okay. Here's what we'll do. If you can get paperwork to Ms. Wood, your lawyer, showing that you've got a DFACS appointment, meeting, hearing, whatever it is on the 11th, then I'll make your reporting date the 12th, the day after that. Does that work?
Okay. Yes, sir.
Okay. So there are going to be two variables for you. Right now, your reporting date is April 3rd. And Ms. Wood's writing all this down. She's going to walk you through it. You're going to need to be in my courtroom by 9 a.m. on April 3rd. If you get to Ms. Wood some paperwork that shows her and ultimately shows me that you got a legit DFACS meeting on the 11th, then your reporting date will be April 12th. That's a Wednesday, 9 a.m., my courtroom. I'll be here. I'm doing drug court that day. If you show up on whichever day ends up being the right one, the 3rd or the 12th, then your sentence is going to be exactly what I said, which is 5 years to serve 6 months. You get credit for all the days you were in back in December and January. And then the rest of your sentence will be on probation. It'll be a special condition of your probation that you submit to regular drug screens at least once a month. But it sounds like you're doing that anyway through that program.
Yes.
And if you don't show up, if you decide I don't want to do this, I'm going to just try to be scarce and hide out, then your sentence is going to be 6 years to serve 3 years. 6 years to serve 3 years. So you'll be buying yourself an extra 2.5 years if you don't show up. So it's real important that you be a man of your word. You're saying this is what I want to do, and I need a little extra time to get my affairs in order. I may even need almost a whole month so I can make it to this DFACS session. Those are fair requests, and I'm honoring them because I think you'll honor your word to be here on the day and time you said you'll be. So we're clear. If you show up on time, in the right place, on the right date, your sentence is 5 years to serve 6 months. If you don't show up and someone has to come looking for you, as in the police do, then your sentence is instead going to be 6 years to serve 3 years. Do you understand that?
Yes, sir.
Any
Ask you another
questions?
question.
Yeah.
What my release date would be? Do you know?
I don't. It won't be any more than 4 months and some days, but it'd probably be a lot less than that because all of this is parolable and you might get 2 for 1 and all that kind of stuff. So Ms. Wood can help you figure out what the latest possible release date is, but it is likely to be less than the date she gives you, especially if you don't make trouble and you stay at Rice Street. They're going to want to get you out the door. And so they may do one of these 2 for 1 things. Okay.
All right. So no prison time, right?
I can't promise you that they wouldn't send you to the Department of Corrections, but it wouldn't make a lot of sense. You would basically go to the diagnostic center. You'd be there for a month or so, and then they'd release you. But I don't control any of that. I set your sentence, and then other people deal with where that sentence is served. Ms. Wood is in a better position than I am to say, hey, I've had 100 clients who went through a sentence that's less than 6 months, and 99 of them stayed at the county jail, or 99 of them went to Oregon because there's a special jail where they hold people who are only going to be there for a few days. I don't know the answer, but Ms. Wood can talk to you about that, okay?
Okay.
But you won't go to Oregon. Don't worry about that. You're either going to be here or you'll be at the diagnostic facility, and it will be, it's a while, it's weeks, but it's not like you're going to be gone for any more than 6 months minus 49 days. Okay.
All right.
All right, Mr.
Yes, sir.
Jordan, anything else in Mr. Harper's case?
Nothing further from the state, Your Honor.
All right, Ms. Wood?
No, Your Honor. Thank you.
Okay, so Mr. Harper, I will see you either on April 3 or on April 12, and Ms. Wood will let you know once you get her that paperwork. She'll get it to me, and I'll give her the thumbs up or the thumbs down. So she'll let you know whether April 12 is a go or if it needs to be April 3. And it's not a guessing game. If it's a real summons or order or whatever it is for you to be there on the 11th, I'm going to respect that and let you go to that. Okay.
Okay.
All right.
Ask Ms. Wood, can I email it to her?
Yes, you can.
I will send you a text message with my email address, just remember.
Okay. Thank you.
All right. Thank you. You're free to go, Mr. Harper.
Judge,
Thank you, Judge.
Judge,
Yes.
have they signed the indictment, or are they signing it electronically?
Oh, thank you, Ms. Rivers. That I hadn't taken a plea in a minute. Mr. Harper, do you authorize my staff to sign the indictment on your behalf indicating that you've pled guilty?
Why not?
Normally you'd be here in court and I would hand you the indictment and you'd sign it, Michael Chad Harper, I plead guilty. But you're not here, you're doing this via Zoom, which is fine. But I need to get a signature. I'm going to ask Ms. Wood the same question, and she's going to say, sure, Judge, you can sign for me. But I need to know that it's okay for me to sign the indictment for you, indicating that, yes, you've pled guilty. Is that all right?
Yes.
Okay. Ms. Wood
Yes, Judge.
and Mr. Jordan.
Yes, Your Honor.
All right. And I forgot to say this as well. Mr. Harper, I find there's a factual basis to your plea, that your plea is knowing and voluntary. And the part of your probation that you're going to serve, the probation that you're going to serve is going to be subject to the Probation Options Management Act, which means simply that if you have a small violation, let's say you miss a meeting with probation, you don't have to come see me for that. You and probation will work through it. But if you have a big violation, you get arrested again, something like that, that comes back to me and we will work through that. Okay?
Okay.
All right. Thank you, everyone.
Thank you.
All right, Ms. Wood, what I'd love to do now is take care of Mr. Kelly. I'm gonna turn the speaker on in his courtroom or his booth. Let's get in there. Five North, booth 4. Decided not to make it easy. Hey, Mr. Kelly, can you hear us?
Yes, sir.
Great. We can hear you as well. This is position 15 on our status conference calendar. It is indictment 22 SC 184611. Ms. Wood, my understanding is that Mr. Kelly would like to enter a plea at this time. Is that correct?
Correct, Judge.
Okay. Ms. Hall, good afternoon. Is this your case?
Good afternoon, Judge. Yes, it is.
How does it feel sitting at that table again?
Different.
Just like old times. What do you mean? It's great. We're glad to have you back. Mr. Kelly, you are charged in the indictment with violating the sex offender registry. In a moment, Ms. Hall is going to put you under oath. I'll add her to the spotlight as well so you can see her. Once you're under oath, you need to answer her questions and mine truthfully and completely. Is this a negotiated plea, Ms. Wood?
Judge, it's technically non-negotiated, but I don't think it'll be as complicated as Mr. Harper.
Okay. Well, Mr. Kelly, just so you know, it's the same as what you heard if you were able to hear it with Mr. Harper. If for some reason and in some way I sentence you more severely than Ms. Wood, your lawyer, is recommending, you and Ms. Wood will have a chance to talk about it to see if you want to withdraw your plea and try something else, or if even though you didn't get exactly what you were asking for, you still want to go forward. So we'll have that discussion. You're not locked into anything until I double confirm that you want to go forward with the sentence if it's different from what Ms. Wood is asking for. And I don't share that with you because I know I'm going to differ with her. I may go along with what she has to say. I just want you to know that today and today only, you've got that flexibility, okay?
Yes, sir.
All right. Ms. Hall, when you're ready.
Yeah. Ms. Kelly, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
I do.
You may lower your hand. Please state your true, correct, and legal name.
Jackie Dwayne Kelly.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone to school?
59, I got a GED.
And are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with 3 counts of state sex offender registry violation?
3 counts. No, ma'am. 1 count.
One indictment, Mr. Kelly, it's got 3 separate dates on it.
I didn't know that. But, okay.
Do you
Yes,
understand?
ma'am.
Do you
I
understand?
now.
Okay. That you've been indicted on 3 different counts for 3 separate years for a violation of that registry statute. Do you also understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
If I could have a minute, it would be nice.
Okay, we can make that happen in just a second. Mr. Kelly, let me explain the indictment situation. I just pulled it up so I could see it as well. The confusion is only this. The indictment alleges that you failed to register in 2019, 2020, and 2021. That's why it's 3 counts. It's all the same offense. You didn't register, but according to the state's evidence, you didn't register in 2019, 2020, and 2021. So there is a count for each of those years. Does that make a little more? Does that make a little more sense?
No, sir, because I registered each one of those years, but 21, I moved after I went and registered in August. I moved and I forgot to turn the address in.
Okay, so why don't I let you and Ms. Wood talk a little bit, and we will pivot to something else, okay?
Yes, sir.
All right, it's possible, Ms. Wood, that you're not gonna be able to hear Mr. Kelly in the breakout room. I know that's happened in the past. So Mr. Kelly, don't be shocked if you can hear Ms. Wood, but she can't hear you. If it completely falls apart, we can do 2 things. 1, we'll bring everyone back in here. 2, we don't have to do this plea. If it's not something you're comfortable doing, we shouldn't do it. After today, you're welcome to enter a guilty plea. You just don't get to withdraw it if you don't like the sentence that you get. So there is a benefit to proceeding today, and you and Ms. Wood can talk about that. So let me get you in the breakout room, okay?
Yes, sir.
Judge McBurney,
Yes, ma'am.
I will text Ms. Feely my announcements for my other cases so that it doesn't hold everyone up.
Excellent. Thank you for that. Okay, they are in the booth. Let's go to Bakari Briney. Is Bakari Briney online? I know that Mr. Rigdon is on behalf of Mr. Fortis, on behalf of Mr. Briney, but we need Mr. Briney as well.
Judge, I was under the impression that Mr. Briney would not have to appear just for the status conference based on my conversation with Attorney Fortis.
Okay, that's not how it works, but maybe Mr. Briney can make an appearance by dropping into this call.
Okay, well, I can step away and try to get Mr. Briney on here, Judge.
Okay, why don't you do that?
Thanks.
And let's go to Michael Palmer, Mr. Adams's cases, and Mr. Palmer is here in court. So let me take that off. So Mr. Adams, you've got two cases for Mr. Palmer, both robbery cases. Mr. Jordan, you have them for the state?
Yes, Your Honor.
Okay. Mr. Adams, do you have discovery in those two cases?
Yeah, we intend to enter a plea today. We have a couple of issues we talked with the state about. But I think-
Okay, but you think today, at some point this afternoon, we can take a plea?
Yes, sir.
Excellent. Okay, then I'll back off on this one, and when you guys are ready, let me know, and we'll take care of that.
Yes, Your Honor.
Okay, thank you. One more we may be able to knock out before we need Ms. Feely to play the role of Ms. Wood.
Position 12 is a very quick announcement, Your Honor. I believe Attorney Watts and I have been communicating.
Good. Well, that's what I was trying to figure out. It looks like Ms. Watts is on the call.
Yes, sir, I'm here.
There she is. Hey, Ms. Watts, how are you?
Excellent, Judge. How are you this afternoon?
I am doing well. Thank you for being here and thanks for your patience. And how about Mr. Kearse?
Yes, sir, he's present.
Would that be TK, the entry on here?
Yes, sir, I believe.
There he
he's
is.
raised his hand.
Yep. All right. I see him. He's on the spotlight now. Ms. Watts, you've received discovery in the case?
We have received partial discovery, Judge. We have not been able to access the Axiom cam, so that Mr. Jordan has agreed. I think he's going to mail that to me since we're 4 hours away. So we're waiting for that, but we've received everything else.
4 hours away, meaning both you and Mr. Kearse are not local, or your law practice is not local?
I am not local. Mr.
Okay.
Pierce is local
He is local. Where's your law practice?
in Albany, Georgia.
Oh, yeah, that is not near. Okay. Is the body cam, in your estimate, Mr. Jordan, something that would yield a motion we'd need to hear, a motion to suppress, or?
Not particularly a motion, Your Honor, but it is important to the case.
Okay, and that part I don't doubt, or Ms. Watts would be saying, hey, I need to see it at some point, but we're ready to move forward. If you're about to mail it, I think Ms. Watts will be getting it in plenty of time. I see that Mr. Kearse's case is on the April trial calendar. It's about a month out. If the body cam footage is not a statement that needs to be considered for suppression or whatnot, I'm comfortable leaving this on the April trial calendar. What do you think about that, Ms. Watts?
Judge, I don't have a problem with that. We are still in negotiation with the state, and we're hopeful that we might be able to get something resolved before that calendar. And I guess we would let the court know. I'm not sure what the procedure would be, or if the court will have a date before that we could actually resolve it.
Yeah, so the procedure, Mr. Jordan's very familiar with it. As soon as in any of his cases, he's lined up a plea, he just reaches out to my litigation manager, Ms. Nelson, And it'll be a whole lot easier for you and Mr. Kearse, because he's on bond, to find a slot where we could take that plea. If it involves custody, obviously Mr. Kearse is going to need to come to court. If it doesn't involve custody, I'm all right with virtual appearances. So you could stay in Albany if you and your client are comfortable that you're not standing right next to him during the course of the plea colloquy. But that's logistics for you and Mr. Kearse to work through. What Mr. Jordan would do is reach out to Ms. Nelson to say, we've got another plea. It's a bond matter. When could we do it? And as long as Mr. Jordan knows your schedule, so we're not booking a time when you couldn't be here virtually or in person, then we're done. We take care of it that way. Otherwise, everyone, you included, need to be here in person for the call of the calendar.
Yes, sir.
Okay?
Yes, sir.
Mr. Kearse, do you have any questions about what we've been discussing?
No, Your Honor.
Okay. Well, stay in touch with Ms. Watts. She'll be talking to Mr. Jordan. She'll get this body cam footage, and you guys will need to figure out how best to look at it together. It sounds like in Mr. Jordan's view, watching that is going to help shape the negotiations, because the video shows what it shows. It's kind of hard to get around it. It's either favorable for the state or it's favorable for you, and we'll process it accordingly. Ms. Watts, if you don't have anything else, you and Mr. Kearse are free to go. We'll keep this on the trial calendar, and it may be that we see you before then for a non-trial resolution.
Yes, sir. Absolutely, Judge. Have a wonderful weekend.
You too. Take care.
Thank you.
Thank you, Your Honor.
You're welcome. Mr. Rigdon, any luck contacting Mr. Fortis's client? I confirmed with my staff that no one told Mr. Fortis that Mr. Briney didn't need to be here.
Judge, that was my mistake. I believe he is on here under the name of Samsung. Mr. Bakari, if you could unmute yourself and call to the court, please.
How you doing?
That was my mistake, Judge, not Mr. Fortis's.
Okay.
How you doing? Do you hear me?
I'm doing okay. I'm looking for, oh, it now has your name on it. It does.
Yeah, Bakari, I changed it. Yeah.
There he is. Okay, you've been on for a while. I noticed that background. All right.
Yeah.
So here's Mr. Briney. Here's Mr. Rigdon filling in for Mr. Fortis. What's the felony in this case?
The fleeing and eluding, Your Honor. I believe it's the speed that made it a felony rather than a misdemeanor.
Okay. All right. Mr. Rigdon, does the defense team, whoever's on it, have the discovery in this case?
Judge, we do, and we need to set this case down for a plea date. A resolution's been reached.
Okay. Then is that news to you, Mr. Jordan, or you agree?
No, Your Honor. The last time that I spoke with Attorney Fortis, it was just a few small tweaks that needed to be made to the offer, but I was assured by Mr. Fortis that this wasn't a case that's going to go to trial.
Okay, then I'll ask you to work with Ms. Nelson and Mr. Fortis's schedule to get this in for a plea. Mr. Rigdon, we've got a date. It's on March 23rd. So I will see you, Mr. Briney, on the 23rd of March in the afternoon. Hopefully Mr. Fortis can join us. If not, hopefully Mr. Rigdon will be here, but you'll need a lawyer with you. And we will be taking your plea on the afternoon of March 23rd.
That sounds great, Your Honor.
Excellent. Any questions, Mr. Briney, about your situation?
No, sir.
Okay, great. Keep in touch with Mr. Fortis, but we'll see you on the 23rd. Thank you, Mr. Rigdon, for filling in.
Yes, Judge. And what exact time will that be that afternoon?
Let me see if the magical box tells me. Get these little texts that provide me my script. I am not able to think much on my own.
I understand. We can find out otherwise, Judge.
Okay. Yeah, it's at 2 o'clock. Came in just in time. 2 o'clock on March 23rd is the calendar for taking the plea in hopefully more than one case. Mr. Briney's case, though. All right.
Great, Judge. And that concludes my business if I may be excluded.
Yep, you may be excused. And Mr. Briney, you're free to go as well.
Yes, sir. Thank you.
All right.
All right. Bye-bye.
So Ms. Feely, do you want to start working through the calendar on behalf of Ms. Wood? I don't know what she was able to text you.
I think I have all of her remaining announcements,
Okay. Well, why don't we start? Jamar Grant.
except for that one.
Okay.
I thought that was already taken care
That's
of.
been dismissed, Your Honor. I did submit a no pause.
That's right. That's right. Okay. I remember 09. What? No pros. Done. Demetrius Benson.
That is ready for, she has everything and has negotiated a plea
Okay.
on both of his cases.
Your understanding is, well, who would handle, are those Willingham?
Your Honor, it's actually kind of a combination of both myself and Ms. Hall. However, we did have another case that was outstanding. It was a CP. I've gotten it accused. Well, as you can see, I'm on Zoom. So I did get it accused. However, I am still waiting to get that SC number. I can check with my other colleague who did that on my behalf to see if we have it, but I believe we are ready other than that.
Okay. And hopefully Ms. Wood was aware that there was maybe it's a universal global resolution of the 3 cases for Mr. Benson. Okay. Great. We'll get Mr. Benson over here as soon as we can to take care of that. Ms. Nelson needs to know when we should bring Mr. Benson over. So we've got Willingham, we've got Hall. Who is going to take the lead in contacting Ms. Nelson?
I can do that, Your Honor. And actually, I just got word. I do have a SC number. So as soon as Ms. Nelson can get us on, we are ready to go.
Okay, but it works in the other direction. So when you're done here, or you can even now start emailing Ms. Nelson, you should send her, here's the other SC number, we're ready to go. And then Ms. Nelson, will get Mr. Benson either on one of our calendars. It sounds like if it's negotiated, we don't even need to publish it. So we could figure out a date and time that works for you and Ms. Wood. And we'll either use one of our 2 inmate days or slot Mr. Benson in on someone else's. He's been in jail for a little while. Okay.
Yes, Your Honor.
Thank you. How about James Robinson? Mr. Hiles is here. Is the James Robinson?
Yes,
Hey,
Your Honor.
you're Mr. Robinson?
Yes.
All right. Let's put you right there. So what is Ms. Wood's announcement?
I think she might be back.
Oh, she is back. Look at that. Okay. There's Ms. Wood. We got partway through. We got your announcement on Mr. Benson. That'll be a plea, actually on 3 cases. We've got Mr. Robinson here. Someone's bowling in the background at his place, but we need to figure out how this case is going.
Judge, I believe I have everything. I have an offer from the state and Mr. Robinson is ready for trial.
Okay. Mr. Hiles, the calendar simply says 2 gang charges, nothing substantive. Is there more to it, or I didn't know you could just say gang charge without then the predicate offense?
Well, you don't have to charge predicate offense. It's the underlying charge in the indictment is reckless conduct. So it's an offense involving a weapon. That's why it's charged the way it is. We just elected not to
Include the misdemeanor.
with the case. So
Okay.
we're ready.
Okay. Let me look this up.
I think it's on the April 12th calendar.
I think so too. Most of these are, I just was thrown off because there were a couple Mays. Yep, this is on for April. So Ms. Wood, you're good to go for the April 12th trial calendar.
Yes, Judge.
Okay. And you have good contact information for Mr. Robinson?
We do.
Excellent. Mr. Robinson, you have any questions?
Yeah, I want to know why they still trying to give me 18 months, and on the video they still waving guns. I wasn't waving them.
So, Mr. Robinson, I'm gonna interrupt you. I hear you. Well, what you want to do is have me talk to you about the facts of the case, and this isn't the time for that. And I think I understand more why Ms. Wood is saying, Judge, we've got discovery, we've received an offer, and we're ready for trial. Because you and your lawyer look at this very differently than the prosecutor does. That's when we go to trial, when the two sides don't see things the same way. So not my job to say, here's why the state's doing what it does. They've got their reasons. Not my job to say, why don't you take your offer? You've got your reasons. All I know is I'll see you again, not on Zoom, but in person when we call the trial calendar for our April trial calendar, okay?
Yeah, I'm ready to go to trial. All right.
Good. Glad to hear that. Ms. Wood, anything else, or is Mr. Robinson free to go?
Free to go, Judge.
All right. Thank you, Mr. Robinson. Trial calendar. Roderick Hargrove is on. He is Atomic Allah. There he is. Hey, Mr. Hargrove. So, Ms. Wood, your case also. Ms. Feely apparently isn't taking cases anymore. Do you have the discovery in Mr. Hargrove's case?
I do. I have an offer, and we are also ready for trial on this one.
Okay. Mr. Jordan, your case?
I don't believe so, Your Honor.
That would be me again, Your Honor.
Ms. Willingham. All right. It's the Wood Willingham show. Let me jot that down. Willingham. All right. So Ms. Wood says she's got your offer. She's got the discovery. And right now it sounds like there's not a meeting on the minds of something that would result in a non-trial resolution. So let me look at Mr. Hargrove's case. 4. All right. April 12th. So Mr. Hargrove, I will see you in court on whatever day we'll call on the calendar. Sounds like you're ready for trial, as is Ms. Wood. The prosecutor's ready, and so maybe we'll reach your case on this calendar, okay?
All right.
Any questions?
None.
None. All right. Well, you are out on bond. Make sure you continue to comply with the conditions of bond, and I will see you and Ms. Wood and Ms. Willingham when we call that calendar in early-ish April. All right?
Thank you.
You bet. You're free to go. Mr. Palmer, we'll deal with in a little bit. DeMarcus Dixon.
He's mine, Judge.
All right. And Mr. Jordan?
Position 13 is not mine, Judge, but position 14 is.
Okay. Who's got 13? Ms. Willingham?
I do, Judge.
No, Mr. Shapiro, because of the cruelty to children charge.
That is correct, Judge.
All right. If Mr. Dixon is going to trial, which case is going out? It's not a good sign when you guys can't decide on one of the cases. This is a drug possession case.
It would likely be ours, Judge, subject to possibly some aspects of our case changing prior to trial.
Meaning a re-indictment or a reduction of charges?
Neither, Judge.
Okay.
I mean, in all candor, the court, we've had some issues with witness contact in this case with one of our victims.
Okay. All right. I appreciate the candor. I bet Mr. Dixon does too, since he's been in jail 250 days almost. Ms. Wood, do you have discovery in both cases?
I have everything except for the body cameras in position 14, and that is one of the agencies that has an issue.
Is this College Park?
It's another College Park.
Come on, College Park. All right. Oh, and the drug case is old. It's already 2 years old, and that's well before June of last year. So we may never see that body cam. Okay. Another reason that we'd go forward with Mr. Shapiro's case first. Okay. Assuming our focus is on position 13, Ms. Wood, you've got discovery, you're ready, and there's not a meeting of the minds right now.
Correct.
Okay. So trial. Is this on the April calendar?
I believe so, Judge.
It's knowable. I just wasn't, I'll look it up right now. It's in the range. Yes, okay. Trial 412. All right, so given the seriousness of the charges and the fact that this is one of the longer jail terms, other than I'm sure there's some major cases that are going to pop up on the calendar, this is one you guys should be looking at. And we'll deem position 13 ready to go. I wouldn't call out 14 if the body cam is central to it, since no one has it yet.
Yes, Your Honor.
All right. Ms. Wood, anything else on behalf of Mr. Dixon?
No, Your Honor.
All right. That leaves Mr. Kelly, who may be stuck in the breakout room still, and I'll get him out, and Mr. Palmer. And that's it. And then we're going to talk a little bit later about the upcoming trial calendar. Ms. Wood, does Mr. Kelly still want to go forward?
Yes, Judge, I think we're gonna attempt to make it through.
I'm going to wrestle through it. All right. Let me close the rooms. Were you able to hear him?
No, Judge.
Okay.
I'm really good at playing charades with my clients.
All right. He'll be in here in 1 second, literally. Now he should be back. There he is. But he's muted, of course. Hey there, Mr. Kelly. Welcome back. Ms. Wood told me that you all had a chance, I'll say talk. She got to talk. She wasn't able to hear you. But what Ms. Wood shared with me is that her sense from your one-way dialogue is that you are prepared to continue with the plea. Is that correct?
Yes, sir.
Okay. Then let's get back on the record in your case and continue with the plea colloquy that we had with Ms. Hall. If you can pick up where you left off as best as possible.
Thank you, Your Honor. Mr. Kelly, do you need more time to speak with your attorney about your case?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So wait,
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
so wait.
Mr. Kelly, have you been arrested on these charges?
Yes, ma'am.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
We do not.
Has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
The minimum and maximum sentence for a state sex offender registry violation is 1 to 30 years to serve. Do you understand that if your guilty plea is a blind plea, also called a non-negotiated plea, the state may still make a recommendation to the court?
Yes, ma'am.
Have you discussed the state's offer with your attorney?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge in this indictment?
Yes, ma'am.
Do you understand this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
And Your Honor, for the record, the state's recommendation for all three charges in the indictment is 5 years to serve 6 months. Credit for time served, balance on probation.
Okay. Any conditions of probation?
Only condition is that the defendant register his new address, accurate address within 48 hours of release.
All right. Is that also the law or? Okay, it's both. The
So
law.
72 hours is the law.
Okay, you're shrinking it to 2 days, given the frustration that's registered by this indictment.
Yes.
Okay.
Mr. Kelly, do you understand if you're currently on probation or parole, your probation or parole may be revoked based on entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, A guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would. And this is true regardless of any advice by your attorney or anyone else.
Understand.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Understood.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Understood.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am, I understand.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
In indictment number 22 SC 184611, how do you plead to 3 counts of state sex offender registry violation?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, it is.
Do you understand that you only have 30 days to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the constitutionality of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, the defendant's criminal history, the state is aware of 2 prior felony convictions, one out of the state of Alabama, which is the leading charge. Yes. And then the other conviction is an identity fraud out of Fulton County on disposition date of January 14th, 2020.
2020. Okay, so this would be while within the time frame of this indictment, but it's identity fraud.
Yes.
Okay.
And had this case proceeded to trial, the state would have proven beyond a reasonable doubt that the defendant was required by law in the state of Alabama after a conviction of the underlying charge to that disposition date, Your Honor, was August the 11th, 1987. Indictment for the Alabama case is CC 1987-547. And as a requirement, he was required to register and update the sheriff's office in Alabama of any address changes. Once he moved to the state of Georgia back in, I believe, 2011, that requirement shifted to the state of Georgia. He was released from prison. When he did that, he reported an address of 989 Kipling, that's Kipling Street, Southeast Atlanta, Georgia, 30315, as his address. He had an annual review back on August the 13th, 2019, where he reported that address as his current address. Again, August 14th of 2020 as his current address. And then again, August the 12th, 2021 as his current address. There was a verification done in 2021 by the sheriff's office in Georgia. Went out to that address to verify that address, spoke with Mr. Kelly's ex-girlfriend who verified and signed an affidavit saying that he had not stated that address since 2012.
Okay, so I think I understand Mr. Kelly's, I don't know if frustration is the right word or confusion. In his mind, he's registering. In the law's mind, he's not, because he's providing an address where he wouldn't be found.
Correct.
Based on the affidavit provided by the ex-girlfriend.
Correct.
Understood. Okay. And the overall recommendation is 5 years to serve 6 months, credit for time served, balance probated, register within 48 hours.
Yes, and I do have from defense counsel, and I'm sure she'll share with you, Your Honor, that his current address should be 328 Archer Way, Atlanta, Georgia. Not sure the zip code. And as far as how long he's been in custody, that's been 224 days today.
Okay. Excellent. Thank you so much.
You're welcome. Nothing further.
Ms. Patterson, did you have anything different? I've got the 2 convictions, one out of Alabama and then a much more recent one here in Fulton County. Did your review of Mr. Kelly's record reveal anything else, if you had a chance to review his record? Ms. Jackson, are you there? Oh, you may be Ms. Jackson. That's not the one I'm looking for.
Okay. Were you looking for me or Ms. Patterson, Your Honor?
No, I was looking for Bridget Jackson.
Okay.
I didn't know if you had been able to run Mr. Kelly's criminal history.
I do have it, Your Honor.
Okay.
There's nothing in addition.
Okay. How many cycles?
There were 9 cycles. That
Okay.
was 8 in Georgia and 1 out of Alabama. So it's a total of 9.
Got it.
I do
And the
see
most recent arrest?
that was January the 14th, 2020 in South Fulton County, Georgia, for forgery in the first degree and identity theft fraud.
Got it. And that resulted in the indictment. Okay. Thank you very much.
Yes, Your Honor.
Ms. Tucson, is Mr. Kelly on probation?
He is on probation at the moment. And it looks like I was just actually going through those dispositions to find out exactly what it was. He was sentenced to 3 years of probation on that 20 SC 174274 case. And so he remains on probation.
How much time is remaining?
He has 1 year, 2 months, and 7 days remaining on that case.
Okay.
And then the probation from Alabama expired in 2017.
Got it. And I'm not in a position to do anything about Alabama anyway. Ms. Wood, I do want to hear from you. My thought is that we resolve the 20 SC case as part of this disposition, assuming you're willing to waive any notice rights Mr. Kelly would have about a revocation proceeding.
And it's warrant status. He does not have a warrant for that case.
Okay, great. That would be another reason why that we'd need to waive notice, because I don't want this to be something that trips Mr. Kelly up 3 months from now. Like, wait a minute, you pled guilty to violating the sex offender registry and you're on active probation for the identity fraud case.
Yes, Judge.
Okay, tell me what you want to tell me about Mr. Kelly, and if you are prepared for me to resolve the probation situation as well.
Yes, Judge, I would very much like to do that. I think Mr. Kelly seems to be nodding his head as if he's not on probation. However, I think it would be in his best interest so that later on a warrant is not issued to trip him up once he is done with this case. So Mr. Kelly, that is my advice.
Mr. Kelly, I would be making it the same sentence, so it's not going to extend anything. I plan on, assuming you want to go forward with a revocation, closing out the 20 SC case so that you're only on probation for one case, which would be this case going forward. Are you comfortable doing that?
Yes, sir.
Okay. All right, Ms. Wood, what else?
Thank you, Judge. He's 59 years old. He's originally from Gadsden, Alabama. His family lives here in Georgia. He has one adult daughter. She lives in Indiana. He does have a GED. He has been gainfully employed for Mac Automotive and then also Liberty Tire Recycling for the past few years. So he doesn't have any issues finding gainful employment. Again, the part of the confusion, he thought he was doing the right thing. And then some of the confusion for him has been once he came here to Georgia, he had a little bit different conditions in Alabama. And so I'm going to help him after this is resolved, try to make sure that he understands exactly what the requirements are here in Georgia. He has been in, as Ms. said, for 224 days. So he was arrested on August 6th of last year. Mr. Kelly's asking the court, since he's served 7 months for registry violation, he's asking the court to consider a sentence of 1 year to serve reduced to the time served. Although he understands if the court is inclined to give him some probation, he would ask that it not be more than 3 years, Judge.
Got it. Okay. Mr. Kelly, do you have any questions about anything we've been discussing?
No, sir, not really. No, sir.
Okay. You feel like you've understood the proceedings?
Yes, sir, I have.
Okay. Well, Mr. Kelly, I find there's a factual basis for your plea. This isn't the typical registry violation I see. You actually were registering, but it wasn't an address that appeared to be legally appropriate. So it's important as you go forward that whatever address you're giving to the sheriff is one that is safely called your home and not one that is your home only if your girlfriend's going to let you call it her home, because that relationship could sour and then all of a sudden it's not your home. It sounds like you'll handle that differently in the future. So I find there's a factual basis. I also find that your plea is knowing and voluntary. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, if you have a minor violation, you and probation will manage that. But if it's more serious, any arrest, any violation of the sex offender registry, that kind of thing comes back to me and we'll work through it. Mr. Kelly, if you were here in court, I would have you sign your indictment indicating your guilty plea, but you are in booth 4 on the 5th floor North Tower. Do you authorize my staff to sign the indictment for you?
Yes, sir, I do.
Ms. Wood
Yes, Judge.
and Ms. Hall. We'll do that. Mr. Kelly, I am going to sentence you to a term of 4 years to serve 6 months with a balance probated on each of the 3 counts of your indictment. I will run those concurrently, meaning at the same time. You'll get credit for all the time you've been in. Sounds like you've been in for more than 6 months. So look who just walked in. Wow. Then you'll be on probation for 3.5 years. I'm going to waive your probation supervision fees for the first 3 months while you get back to work. You will have 48 hours, 4/8, that's 2 days, to get back to, you know where to go. You go to that office and register the correct address, whether that's 328 Archer Way or 123 Main Street, wherever you're going to be staying, that's the address you need to get to the sheriff's office. Any questions about any of that?
I wish I could get that time served and suspended bound.
So that is what you were wishing for, but because we had these hiccups with you registering, and the fact that you're actually on probation right now, I could give you time served and suspend the balance. You'd still be on probation for a while in that other case. But let me wrap it all up. In that other case, 20 SC 174274, I'm going to revoke 6 months of probation. I'll give you credit for all the time you've served. I'm going to suspend that balance. So you're now down to being on probation just in the new case that you picked up, and you'll need to take care of that business. Any questions about any of that?
Well, no, sir. No,
Good.
sir.
Ms. Hall, anything else?
Nothing from the state, no.
Ms. Wood.
No, Your Honor, thank you.
Ms. Tucson, do you need to give Mr. Kelly any reporting instructions?
Mr. Kelly, do you know where the probation office is in Fulton County?
On
Memorial Drive,
Memorial Drive, yes, ma'am. I know where it's at.
276 Memorial Drive.
Yes, ma'am. I know where it's at.
Okay, just make sure that when you are released from custody, you do report, okay?
Yes, ma'am. When would that be?
That I don't have control of when you're released.
You should be released, Mr. Kelly, real soon. How many days do you say he's been in, Ms. Wood?
224, Judge.
Okay, so that's more than half a year. So you've done 6 months. So it's a Friday. It may be that you're not released till Monday. You may be released in the middle of the weekend. You can't report to probation on a weekend. You can only report during weekdays. But if I were you, on Monday, I would make 2 appointments. One is to hit probation and one be hit the sheriff's office. They're only 2 blocks apart.
But they said recommended. Now, I'm just saying what I heard, what I was told, right? I can't quote none of it, I'm just saying what I was told. It said recommended now by the judge, my paperwork get on over, I can leave tonight.
It may be that you leave tonight. I wouldn't bank on that. I haven't signed anything. Until I sign it, you don't have a sentence, okay?
Yes, yes, sir.
All right, Mr. Kelly, good luck with everything. You're free to go.
All right, thank you.
Hi, Mr. Kelly.
Yes, ma'am. So, Mr. Hiles, real briefly on Max Pritchett. We haven't been able to successfully get through a Ferretta hearing, so he's not officially pro se, plus Jesus is his lawyer anyway, but we do need to have a hearing. You had mentioned, let's do the 418, have him be in here for that. We'll do that. My case is going out first next week with Emerson. I can't do another one until all the other judges get to do one. So I need to send an email to Regis, but we will not be doing Robinson and Pritchett. We do need to have a court date soon with Pritchett, just Pritchett, to figure out how we navigate that. And I will be open to your thoughts as well. He has every incentive to make life difficult and whatnot. I'm not going to hold Robinson hostage to that. And so it may be, and I'm saying for sure, but it may be that we try Mr. Robinson and figure out later what to do with Pritchett, who is going nowhere anytime soon.
I have some filings to make.
Good.
It may well be that we were trying Lauren Riley and Tyler Robinson together now.
Oh my goodness. Okay. Your case has always evolved. This is fascinating. And maybe Hall and Pepper and whomever can testify in that case.
I love that.
Yeah.
This isn't really an evolution. This is, I'll just wait for you to read.
Yeah, because we don't have any of the other sides here. But I got a message from Ms. Nelson saying, hey, I got this, they're on a trial calendar, and they were there, but I only get one turn before everyone else gets one, and Tutman's going.
So I'm going to release, I had two witnesses served out of state through the Uniform Act.
Yep.
I'm going to release them this afternoon. Then.
Please do. And we may need to specially set it depending on how all this is flowing.
And then I've yet to speak with Mr. Regis. I've been calling for 6 weeks.
Join the club.
And I know he's been busy too. I don't know how they do it, but I had told Mr. Hoover this. So
Mr. Hoover's not on the case.
So that's the thing. I sent, Mr. Granum's was Max Pritchett's attorney.
Yes.
Mr. Hoover took over.
Oh.
And he had discovery, and then I did not realize that he is also Mr. Regis' supervisor. So it's the same office that got discovered twice.
Okay.
On co-defendants.
Okay.
I'm hoping they will waive, but I feel like that's a conflict I need to put on the record with both of them. And
Okay.
give them the opportunity to waive.
Well, and it'll be moot also if Pritchett represents himself, but we'll figure it out. Maybe it won't be. We'll see.
Yeah, we'll draw some bridge, and then if we have a hearing, I'm gonna play some jail calls that directly relate to the threat of motions and hearings.
Got it. No, I've had some conversations with deputies too, who interact with him outside the courtroom. So.
Your Honor, another matter that was not on the calendar, I have Ms. Jackson here. She was under the impression that the men alleged to have murdered her sons were on for a bond hearing today.
What case is that?
It's the case number is 21 SC.
Hold on one sec. Let me get over there. 21 SC.
179984. I think it's Shay O'Neill.
Yes, I know the case. Mr. O'Neill has a new lawyer. He had Mr. Melnick. Mr. Melnick had a conflict because Mr. Melnick represented one of either a witness or a surviving victim in the case. And he had to roll off. Mr. O'Neill now has Ken Shepard as his lawyer. And what is coming up next in the case is, and I think, Ms. Feely, do you have Carlisle?
I do.
Ms. Feely represents Mr. Carlisle. We have an immunity hearing, and maybe that was going to be today originally. It was postponed because Mr. Shepard is newly on the case, had trouble getting the discovery from Mr. Melnick. I think ultimately the state pushed it to him. It's not your case. I appreciate you navigating this for Ms. Jackson. But
That hearing set for the 25th of April, is that a firm date? I looked it up briefly while I just want to be able to give her a firm date.
Ms. Nelson, we moved the O'Neill and Carlisle immunity hearing at Mr. Shepard's request. Okay, yes, the 25th is, Mr. Shepard has said he can be ready by April 25th. April 25th at 2:00 is when we'll have that hearing. Hope we can do an entire immunity hearing from 2 to 5, but we'll at least start it then. That's going to be an evidentiary hearing. So witnesses will be testifying because the defendants are asserting that they shot in self-defense. And so they don't just get to write that on a piece of paper. I actually have to hear the evidence, and then I decide whether the case keeps going or if it's real clear that they've fired in self-defense under the law, it may be that they're immune from prosecution. I don't know. So you'll want to be there.
Yes, sir. Thank you, Your Honor.
You bet.
You was the judge that sent my surviving son down the road. He been a change man ever since.
Well, you're welcome. All right. Okay. Mr. Adams, are we ready to go with Mr. Palmer?
We can have 5 minutes for me.
Okay. You may. We were going to talk about the March trial calendar. You don't have anything on the March trial calendar?
I got April and May.
Okay, you don't have, no, you don't. And it sounds like Ms. Cabrera Damore is getting discovery and will be plugging in with Ms. Boyd, which is good.
Yes,
okay.
There's one matter, Your Honor, on the March trial calendar that doesn't directly involve 88 Hiles, but it's with Mr. Quindarius Rhodes. It's a complex unit matter, but he has 2 cases. He has a gang case that was, I believe, on the same trajectory to be on this March 27th trial calendar. I think the hangup is that Mr. Vernon Smith does not represent him on both cases just yet. So I wanted to discuss that with the court once we talked about the March 27th trial calendar.
Okay.
I saw your email. You got to work it out. That's your case. And
I got you.
Maybe whatever offer you have, I would like compare it. So just tell me what your offer is.
Got you. Okay.
I have it happening. It's with me.
Okay. Got it.
Thank you, Reed.
All right. Thank you.
Well, why don't we start informal? You keep talking. We won't talk about your cases on the trial calendar, but just to use folks' time, because we've got Ms. Willingham on, and we've got Ms. Feely right here. Heavenly Mitchell is on the calendar. Ms. Feely, is that one? I'm just looking at the calendar now because I realized, wait, you're going to be in trial next week. So we call the calendar next Wednesday, but the trials start the week of the 27th, but you will have been on trial the week of the 20th. But Mr. Mitchell's in jail. What is your thought about readiness? And there are plenty of other cases we can try. They're not as old indictment wise, but there are people who've been in jail much longer than Mr. Mitchell. In terms of, hey, I'd really like to go out first because this needs to go versus I'll do it if you reach me. Where are you on Mr. Mitchell?
I mean, it's ready. It's been ready. So I think this is one that I could still try, but we are still going back and forth, trying to negotiate something short of trial.
Okay. And Ms. Willingham, am I correct that this is your case?
It is, Judge, and I am all ready to go on it.
Okay. Does it involve witnesses from out of state?
Your Honor, no, it does not. It looks like all of our witnesses will be local. I will notify the court that when I spoke with one of the officers today, he no longer is with APD. He does have a scheduled work trip. However, the state's ready to go on it.
Okay. Got it. I hear you. All right. How about, since Mr. Shapiro is here, John Connor, and that date that on the calendar, it says he's been in jail for 546 days. That understates it by probably 1,000 days, if not more. Not on you guys. He was in Douglas County forever when Douglas County was swearing, and this predates both of you. It was a Macaulay case and by a Siri Patel case. I mean, that's not the right name. Shamal Patel. Douglas County was going to plead it out and resolve everything, and then they dismissed it. So here we are. And Mr. Connor hasn't been well, but is doing better. Ms. Feely, what's happening from the Connor side?
I spoke with him this week with the latest plea offer, and I think this may be something that can resolve on March 27th.
On March 27th, as in when we call?
Or March, well, depending on if I'm here.
Okay.
I think I would need to be here.
You need to be here. Okay. So, all right, we need to work through that, but it's sounding like people are close enough together that banking on this as our trial would be unwise on my part, because having a jury busting on in here is probably going to make it resolve, if not before then.
And Judge, I'll also mention, I was checking to see if this case is specially set, but I know I'm scheduled to be in Judge Ingram's courtroom on a separate trial also to begin the 27th. I believe that is special set. I'm trying to confirm that right now. But as Ms. Feely said, we're hoping to resolve this one short of the trial. Okay.
But Ms. Feely, your connection with Mr. Connor is such that you'd need to be here for the plea.
I would want to be here. I think
That's all you need to say. I mean, if that's how you want it to be, then we'll need to sort through how we necessarily pull that off. But if we need to try something else because the other thing's ready to go, it sounds like rather than wait for a whole nother trial calendar, we could get Mr. Connor in here. Yes. All right. Well, we got all the right people here again. Shari Grant, that was ready before. It's ready again, I assume.
again, I don't have a current offer. I'll reach out to Ms. Willingham because I believe Mr. Whitenauer had withdrawn the latest offer on.
Okay. Were you able to hear that, Ms. Willingham?
I did hear that. I will reach out. I guess Ms. Feely and I can talk after this.
Okay.
I mean, but as mentioned, Your Honor, it was one that was already ready to go. So we're still in that posture.
Okay. Good to know. We'll wait to hear. I don't know who's going to announce for Muckle, but I think it's ready. I've been bugging Mr. Hoover and Mr. Abate on that. Mr. Jordan, what about the Loomis case? Guy's been in jail for a long time.
Your Honor, the state is ready on that matter. I did extend a new offer to Attorney Butterfield that I anticipate that they may accept, but the state's ready and doesn't have any concerns with any witnesses.
Okay. Mr. Butterfield at one point was waving around some kind of competency question mark. And I don't know if there's nothing in the docket, but I hope that's not what suddenly happens come the 22nd.
He hasn't voiced that to me, Your Honor, but
Have you actually had exchanges with him, whether they're voice or email?
Via email. Your
Okay,
Honor.
good. I mean, he ought to bring it up if it's something substantive.
Yes, Your Honor.
So it may work out. You're ready to go.
Yes.
Okay. Ms. Willingham, Anthony Johnson, if that doesn't resolve, and maybe you know it's going to resolve, but is that something you could be ready on?
Your Honor, I saw where there was a leave filed by Mr. Jones, and he and I spoke, and the leave is actually based on some medical stuff with his spouse, I believe.
Uh-oh, okay. Oh, I hope that
we're speaking. I think it may be something we may end up being able to resolve, but he's not in a posture right now to be able to discuss the case.
Yep. Okay, let me look. I just pulled that up. Ooh, yeah. Yep. Okay, so we'll need to move this one to May. Thank you for flagging that. Ms. Willingham, the next case with Ms. Castillo and Mr. Santiago.
Yes, in both those positions, Your Honor, I have extended a offer that I think will allow us to resolve it. I know that I'm waiting to hear back regarding Santiago. And I believe it's my understanding I should hear back by Monday for Santiago. As to Ms. Castillo, I will double back with Mr. Richardson today, but I do anticipate those are going to resolve. As to Mr. Santiago, his attorney is tied up in that wonderful case that is going to keep everyone tied up probably till 2025, it looks like.
Mr. Apt is in YSL?
Yes, Your Honor. And he is the lead attorney on his client's case in YSL. So.
Okay. Well, I know they get breaks. So if this is something that's going to be a plea, we have moved cases involving, other than Eric Johnson, involving YSL lawyers who parachute in and say, great, I'll take this plea, I'll do this hearing. We even did a motion for new trial hearing, getting a YSL lawyer in here. So if you confirm with Mr. Apt, and similarly, he is lead on Mr. Santiago, but we have had a colleague of his appear and argue things on behalf of Mr. Santiago. So if you're able to confirm that it's worked out, we can work with his office to either find out when he could get a break from YSL or if a colleague could be involved in taking the plea.
Yes, Judge, and it is my understanding from speaking with him that in the event we can reach an agreement, that is exactly what he intended to do. I'm just waiting to hear back. So once I hear back from both him and Mr. Richardson, I will notify Ms. Nelson.
Fantastic. Raymond Carter, I saw some email traffic about that. What was that?
Yes, Your Honor, that is going to be a plea.
Huh. It's funny how the change from Whitenauer to Willingham, we're getting some case movement. Thank you, ma'am. All right. And do we have that down on a calendar somewhere?
Yes, Your Honor. It is my understanding we're going to take that on the 22nd.
All right. Yeah, that's right. That's exactly what I saw. Cool. Okay. Mr. James, where are we with that, Mr. Jordan?
That will be a negotiated plea, Your Honor. I believe Attorney Roberts is online as well.
Oh, fantastic. Boy, she's been having to sit around for a little bit. Ms. Roberts, are you with us?
Yes, Your Honor. How you doing?
You've been in the car the whole time?
Your Honor, I had a very busy day. I had court this morning in Lethbridge. Then I had to run to the jail. And then, so yeah, it's okay. It's raining, you know.
You're chilling and you got that nice moon roof and it's a nice place to be. Looks like all leather interior. You get paid well. No. Okay. Well, someone lent you a nice car. Do you agree with Mr. Jordan that through your good efforts and his, we'll be resolving? I don't know if there's more than 3. I know there've been a lot of cases for Mr. James, but all the cases you're helping on with Mr. James, those will be resolved?
Yes, Your Honor, all 3 of them.
Okay. Are we doing that the call of the calendar? Okay, great. So we will see you the day we call the calendar, Ms. Roberts. We'll get Mr. James produced and we'll take care of these cases.
Okay, thank you, Your Honor.
Thank you. Enjoy the rain.
Thank you.
Thank you also, Mr. Jordan.
Yes, Your Honor.
Well, we're on a tear. Next one's a major case. Can you just tell me that it's worked out? Carlos Dill. We would do Muckle before Dill if we are going to try a homicide. Was Mr. Dill one that we had delayed because it's always ballistics, or I say delayed, that we had continued once, or is this its first time on a calendar?
This may be his first time on a trial calendar because he was in Department of Corrections for several of his court dates.
Okay.
This is another one that I think Mr. Whitenauer withdrew his offer, so I'll get with Ms. Willingham to see if there's any way we can work this one out. Okay.
Ms. Willingham, anything you want to add about the Dill case?
Your Honor, in all candor, as to Dill, I can get with Ms. Feely, but in all candor, Your Honor, I would not be ready on Dill. I've shifted my focus to 2 other cases that I thought had greater potential to go.
And what are those two? Just so I'm,
That was Miss Mitchell and Miss Grant.
okay. Heavenly, who's a guy.
You're right. I'm sorry, Mr. Mitchell. You're
It's
correct.
okay. And Ms. Grant, and that's fair enough. And like I said, we would do Grant before we would do Dill. So you are prioritizing correctly. I think we'd probably do Muckle before we would do Grant, but we'll see. We'll call the calendar and see what we're going to do there. All right. Well, let's keep pushing. Well, let me ask, are we ready to go on Mr. Palmer, or should I do a few more positions here?
Not just yet, Your Honor. We're
Okay.
still negotiating.
Keep the shuttle diplomacy going. So Mr. Rhodes, this is the one you had wanted Mr. Hiles to hear something about. And I know Mr. Smith's not here. We don't need to talk substantively about the case, but is it something you're ready to try? It's a big old bond, some serious sounding charges.
Yes, Your Honor. The state would be ready. I haven't extended an offer yet because I just wanted to see if there was any way that if Mr. Smith could get up to speed on the new case, but apparently he hasn't been hired on the gang case.
Has that been assigned to this division?
It has been assigned to this division, Your Honor, and I believe it has a plea and arraignment date for the 23rd.
Oh, that's how new it is. Okay, it's just coming in. And he's on bond for that too?
Your Honor, I believe that this case, the gang case, may have predated the offense that I have, and then Mr. House just re-indicted it because it was on a plea and arraignment calendar for February 7th.
Okay.
And then it was moved to see if Mr. Smith would be representing him on both cases.
Okay, but you'll be ready to go on this one, regardless of what's going on. Does the new one have more serious charges?
It does, Your Honor. I believe it's somewhere in the neighborhood of a 20-count indictment, and it's
Doesn't mean it's more serious charges. Those gang indictments always have a million charges, and sometimes it's a whole bunch of entering autos.
Absolutely.
This is an ag assault shooting ad. Do you have the case number?
Your Honor, if I can.
It doesn't show up as a related case in, Odyssey is not famous for that.
I just sent ADA Hiles an email on it, so I'll have it for you in a second, Your Honor. I know let's see, I put the same case number in here twice. You'll give me just 1 second, Your Honor. I do apologize.
No, that's all right. I'm looking too. That's not gonna be it. Don't worry about it. It is what it is. You'll be ready on this if it's something we need to work on.
Yes, Your Honor, and I'll make sure, I don't believe I've sent an offer to Attorney Smith, so I'll make sure to send one out today before the close of business.
Okay. Ms. Willingham, Quachez Dawson, and you got to meet him and his lawyer recently.
I did, Your Honor. And as you know, we did extend an offer. It is my understanding that they will be accepting that offer. However, I have not heard back yet from his lawyer since probably about the day after we met. So I will double back on that, but I do think that that is still a offer.
Okay.
I mean, I'm sorry, a plea.
Yep. But it sounds like we may not take that till we call the calendar when everyone is back in the room again.
Correct. Hopefully at 1 o'clock when the calendar starts.
Yep, exactly. Okay. Malik Henderson. Mr. Shapiro, your case?
It is not, Judge.
All right.
Henderson, I have listed as SB 414 with ADA Kaufman, I believe.
Well, Rachel Kaufman is his lawyer. Mr. Henderson, he's SB, he's an adult now because he was at Rice Street and got the living daylights beat out of him, and we had to move him to Cobb. He was a priority issue briefly because of what was going on at the jail. That doesn't mean that it wasn't originally SB 440 and he aged out of a YDC.
I'm seeing if we have any recent trees that might help us find the designer.
Well, you can look that up. Let me, Mr. Abate just walked in, so, and we happen to be on one of his unit's cases. ADA Kimberly Carey, you're right. It is, that's the SB 440 person. So, she represents the state. And now it's all clicking. Not only does it say it on the calendar that that was a defense attorney, but she was involved in some of this. Let's figure out how to get them to Cobb County because of what was going on at the county jail.
There's also a motion for continuance filed by the state, it looks like, in Odyssey.
Oh, okay. Well, I will take a look at that. Jamel Lewis is one of the murders on here. And it's relatively new in terms of an indictment. Ms. Feely, that's your case. Something that you could be ready on, not so much because you'll be trying Tutman next week.
This is the one that had outstanding ballistics, and we've followed up a couple times.
This is one that we bumped once already to, or maybe Mr. Abate had already flagged this one saying we're sending it to ABC Ballistics to get it done rather than GBI Ballistics.
I think it hasn't been on a trial calendar. I think it was a status counter that Mr. Body
Okay.
told us about the ballistics.
How are we doing with Mr. Lewis?
So it's still with the private lab. It should be, from what I've been told, sometime next week. The ballistic should be back. He's received a lot of cases from our office because of the backlog of GBI. And I think in all candor, there was a little bit of a payment issue that has been resolved. So
He had slowed his work down a little bit. Yeah. Okay. Got it.
Any other forensic stuff that we're waiting on this one?
I don't believe so.
Okay.
Okay. I'm going to say ready-ish, but it's the double whammy of you being in trial next week. And we might do Heavenly Mitchell if we're thinking of your capacity before we do this, if it's its first trial calendar. I just don't want it to get too gray before we tackle it, but one more cycle is probably okay. Okay. Mr. Abate, tell me what you think the likelihood is of Muckle going forward. You ready to, first, will it be you? Ms. Olivier dropped the bomb that 2 weeks with McBurney, she's burnt out.
It will be me, Your Honor, yes.
Okay.
I would announce ready, so I would say it could be ready. My only issue is a personal issue. I do have a leave that I'm supposed to take on Friday of that week.
Supposed to, I like the supposed to. You should, okay.
My request would obviously be a different week. I think we would go into at least Friday.
So you're saying the 31st, you have leave?
I do, yes, Your Honor.
Okay.
And I apologize, I didn't file leave. I know people do, but the state is the state is the state.
Some do, some don't. Some judges care, some don't. So I understand why people don't. I've been surprised. I saw leave. Ms. McFarland was able to get out of something with a particular judge because leave had been filed. So, yeah. So if we picked a jury on Monday, we'd still be going on Friday. And you're not as comfortable leaving it with whoever your trial partner is on Friday.
That's correct, Judge.
Okay. Getting Mr. Hoover is complicated. And so if we have Mr. Hoover, I'm reluctant to say, let's punt it, because we could punt it once for you and then it's 3 cycles before we get Mr. Hoover again. I'm assuming he's going to be here. He hasn't said he won't be. He dropped the Daubert motion and one other. We can work through all that. But I'm not anxious to interfere with the leave that you've got. What else? I don't think that's one of the, I think he is I've been in jail the longest guy on here. Mr. Connor's been in jail longer, but that was Douglas County days, and it sounds like that's going to be a plea anyway. Muckle doesn't sound like it's going to plea, having met Mr. Muckle. So that's what I'd like to do. But you don't think there's a team you could put together where you would let yourself take the leave you need to take if the case wasn't done by the 31st.
I don't know if we have the bodies, is what I would say.
I get it. I get it.
But whatever the court decides, I'll make arrangements, or I can make it
Are you out the following week or just that day?
that day.
Okay. All right. Could you be ready on Lewis? Oh, we could run into the same issue if Lewis would go till Friday. It really doesn't matter which you could be ready on unless there's one where either you think it'd be to the jury by Thursday, or you worry less about your trial partner navigating it at the end.
Probably said we're less about that. I'm hoping that one resolves. I think we've made an offer of 10 years to serve. So I'm hoping that we can somehow resolve that case.
Is that something you're aware of?
It is.
Is Mr. Lewis aware of it?
I believe I had the offer when I last spoke to him, yes.
Okay.
So he's thinking it over.
He's thinking it over. All right. Okay. We'll work through that. The last one on the calendar is Mr. Hurd, which is Bruce Harvey's case, but we moved it once already. And so he had a sidekick who said he'd be ready for it. Ms. Willingham, have you had any communications with the defense team in the Hurd case?
Your Honor, I have not. I did send a email, but I did not hear back. So I have not had any communications with Mr. Harvey.
Okay. I know a lot has happened before you, but this case has morphed from murder to felony murder to voluntary manslaughter. It's now indicted as involuntary manslaughter. So the way the indictments keep going, it seems like it's a workoutable case.
Yes, Your Honor. From my review of the case, as well as my discussions with ADA Whitenauer, I do still think that there is something that we can work out. I just need to be able to speak with defense counsel.
Got it. Fair request. Okay. Ms. Wood or Ms. Feely, did you have any other questions about or alerts you wanted to share about cases on the trial calendar?
No, I have one add-on that was Tony Clark. I don't have the case number, but it's a ag assault shooting in the leg case, and he's in Department of Corrections. But I think Ms. Nelson said she was going to bring him for that calendar.
And add on to try it or to work it out?
I wasn't quite sure, but it is on for the 27th.
Okay. It was as in you have a piece of paper that has that, or you requested it?
No, there's a calendar.
Okay.
But
what Ms. Nelson is saying that, she had to, in order to get him produced, she had to have a date.
okay,
So
he's not going out on the 27th.
No.
Okay, thank you.
Yep. That's just we needed to give DOC a date, and so that's their date.
Understood.
Was there a reason why we wanted Tony Clark here? We may have some other event for him. I don't know. Is your case?
It is my case.
Okay. Hopefully it will all become.
I believe he's on that April trial calendar, Your Honor. So I don't know if we were trying to get him here ahead of time.
Yes. So you at some point expressed the desire to have Mr. Clark around to prepare for trial. And that's why he's being produced.
Okay, I think the date, because it was the 27th.
Through you thinking, wait a minute, I did want him here, but I'm not ready to go. It's not, it's for the April trial calendar.
Thank you.
So he'll be making landfall soon. Okay. Ms. Wood, did you have any questions or concerns about I don't know that you have many cases on it, this March trial calendar?
Judge, I think you put all my cases on the April trial calendar, so.
Well, good. Why don't you get ready for that one then? All right. Mr. Jordan, we can talk when we've got the other defense attorneys here as well, meaning on the 22nd, about how we would maybe rank your cases. And same with you, Ms. Willingham, and you and Mr. Jordan have a bunch of cases on here. It's only 1 week, so we can only try one case. But it may be that putting a few cases ahead of one that we know is going to be a trial will get some movement on those other cases.
Yes,
Mr. Abate, I don't know what your Friday situation is. I don't want to create a financial hardship as well. How does it work? Like, do you need to know tomorrow so you can cancel, not cancel? Or if on the 22nd, Mr. Hoover walks in saying, you know what, I've got this conflict, and you learn then that we're not doing muckle, that you can still do what you wanted to do on the 31st.
I'll be honest, I don't, well, I'll just like, I don't know what the cancellation is.
Okay.
The policy.
Okay.
Flights in a hotel,
Okay.
tickets.
All right. We'll see what happens on 22nd.
I know I can't get the money back for the concert, so.
Okay.
My anniversary, if that helps.
Yeah. All right. Good to know.
Only happens once a year.
It does. We'll let Mr. Muckle vote. All right. Then I think we are done, other than seeing if Mr. Palmer wants to go forward with pleas in his 2 cases.
I think we do, yeah.
All right. Then why don't we clear the decks of everyone else? Good luck next week. I'm gonna drop by Monday morning just to make sure Judge Emerson has everything he needs.
Judge, if I could ask you a quick question, I know we're not here on that matter, but one of the state's witnesses is in custody at Fulton County Jail. I prepared a order to have him produced. I just didn't know if that should be given to you or to Judge Emerson.
So Judge Emerson won't know what to do with it, but we have given him litigation manager support. And so what you'd want to do if you've got a proposed order is to send it. I don't know if you've noticed on some of those emails, there's this sca.jury. Why don't you send it to me?
Okay.
And then I'm going to send something to you and that address saying, here's a production order for a state's witness. Going forward, we ought to be able to tell all the lawyers if you've got something where you need litigation manager support, and the decision will either be the judge who sent the case needs to deal with it, meaning it would be Ms. Nelson, or here is this support team for Judge Emerson. And I think it's going to be the latter. And so you'd send something to this sca.jurytrial, whatever it is, at fultoncountyga.gov.
Okay.
All right. But send it to me and I'll make sure it happens.
Will do. Thank you.
All right. So Mr. Adams and Mr. Palmer, if you come to the defense table, please.
It also helped, remember I canceled my transcript.
Thank you, Mr. Abate. I want to keep you in your relationship. I also really want to try Mr. Muckle. Okay. Yes, Ms. Jackson, we're going to take this plea. I know it's 4 on a Friday, but we're going to take the plea in Mr. Palmer, and then we are done. So let's get to that. Ms. Rivers, you ready?
Yes, I am.
Thank you. Positions 10 and 11 on our status conference calendar are Mr. Palmer's cases. 22 SC 184581, 22 SC 184637. Both involve robbery allegations. Mr. Palmer is represented by Mr. Adams, and Mr. Jordan is handling the cases for the state. Mr. Palmer, are you ready to go forward?
Yes, sir.
Good. I've worked with Mr. Palmer in the past, just for full disclosure, through our accountability courts. Mr. Palmer, in a moment, Mr. Jordan will be putting you under oath. Once you're under oath, please answer his questions truthfully and completely. If at any point you've got questions of your own, let Mr. Adams or me know, and we'll do our best to answer them, okay?
Yes, sir.
All right.
Your Honor, before we begin, this is a global resolution to both cases, position 10 and position 11. On indictment number 22 SC 184637, the state has agreed to dismiss the robbery by force count. So Mr. Palmer will only be pleading to simple battery on that.
Okay.
Mr. Palmer, can you please raise your right hand?
Excuse me, Mr. Jordan, can you pull the microphone towards you?
Yes, I can. I apologize, Ms. Rivers. Are you able to hear me now?
Much better, thank you.
Absolutely. Can you, do you swear or affirm that the testimony that you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Michael Leonard Palmer.
And can you spell your middle name, please?
That's Leonard.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
I'm 34 years young and I'm a high school graduate.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with the following offenses? In indictment number 22 SC 184581, you have been charged with the offense of robbery by intimidation. And indictment number 22 SC 184637, you have been charged with a count of robbery by force and one count of simple battery.
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Mr. Ed Adams, about all of the facts and circumstances known to you regarding the charges in these indictments, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with his services?
Yes, sir.
Mr. Adams, do you waive formal reading of the indictment?
We do.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Palmer's name?
We do.
Mr. Palmer, do you recall having been arrested on these charges?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Mr. Adams, do you know of any outstanding warrants that are related to these charges?
We do not.
Mr. Palmer, has your attorney advised to you the minimum and maximum sentence for each charge that you are pleading to?
Yes, sir.
And Your Honor, for the robbery by intimidation, the minimum is 1 year and the maximum is 20 years. And as for the simple battery, the minimum is 1 day and the maximum is 12 months. Mr. Palmer, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, in indictment number 22 SC 184581, the state's recommendation is 5 years probation as to the robbery by intimidation count. The special conditions of probation being that Mr. Palmer not return to the incident location. We would also ask, Your Honor, these are both MARTA station related crimes. If the court can impose a ban on Mr. Palmer going to all MARTA stations.
And these are train stations or bus stops?
Your Honor. This was Lindbergh MARTA station. I know that doesn't help, Your Honor.
Well, but that's a MARTA state, that's a train station.
Okay. Once again, Your Honor, I know you've.
Oh, that's right. You are not from here.
Yes, but.
So that's a big old train station.
Yes, Your Honor. So we would ask that he be banned from MARTA train stations, Your Honor.
Okay.
And have no contact with the victim. We also would ask that he undergo a mental health evaluation and follow any recommended treatment.
Okay.
And as for the next indictment, 22 SC 184637, as previously stated, the state does recommend to dismiss count 1, robbery by force. And as to the simple battery count, the state's recommendation would be 12 months probation to run concurrent with 22 SC 184581, and also that he have no contact with the victim in that case. Mr. Palmer, was that the negotiated recommendation that was communicated to you?
Yes, sir.
Do you understand that the court does not have to accept that recommendation?
Yes, sir.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Do you understand, are you currently on probation or parole?
No probation, no parole.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
You meaning as far as hypothetically speaking, being put on probation and committing another crime, then again, the maximum sentence will have to complete?
So I can explain that further. Do you understand that your guilty plea may affect your right to vote?
Oh, yes, it's correct.
Understood. So I'm going to list off the things that it could affect now, and you just can tell me if you understand at the end of
Yes, sir.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and finally, the ability to obtain employment?
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in the commission of a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
Mr. Palmer, how do you plead to the charges of simple battery in indictment number 22 SC 184637 and robbery by intimidation in indictment number 22 SC 184581?
Guilty.
Thank you. Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that you have only 4 years from today for the felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And for the misdemeanor, you have only 12 months from today to file the same petition?
Yes, sir.
And Your Honor, for a factual basis, if we can begin with the robbery by intimidation, which is 22 SC 184581. Actually, Your Honor, my apologies. If we can please start with the 22 SC 184637.
Okay.
That was on January 4th of 2022. MARTA police officers were dispatched to a call regarding a naked female. The victim, Angela Villa, and Angela is spelled Angela. Villa is spelled VIA, explained that she was sleeping when she was approached by the defendant, later identified as the defendant, Mr. Michael Palmer, who told her to take all of her clothes off and forcefully removed her clothing. Ms. Villa stated that she and the defendant are homeless, that she recognized him from Woodruff Park. While walking with officers, Ms. Villa did spot the defendant, and officers observed the defendant placing clothing items into a backpack. The defendant was arrested, where he claimed the victim was his grandmother. Officers reviewed CCTV footage where the incident was captured, and Ms. Villa did also complete a victim statement. Your Honor, to be more sufficient for the simple battery, I believe the simple battery allegation came while that he was forceful while taking her clothes off. Your Honor, in regards to the robbery by intimidation case,
I'm sorry, I missed one thing. Was this at Lindbergh MARTA also? You mentioned, I didn't write down which station it was at.
Actually, Your Honor, this incident location is 216 Peachtree Street Northeast.
All right. Keep going.
And Your Honor, on the robbery by intimidation, on December 18th of 2021, the victim, Mr. Michael Powell, and that's Michael has normal spelling and as well as does Powell, reported that he was robbed at Lindbergh MARTA station by a black male. Powell stated that the black male approached him and grabbed his bag and stated, "Give me your stuff or I'm going to blow your head off." Once assigned the case, the detective from the MARTA Police Department did review the CCTV surveillance footage and observed the incident. And Your Honor, it was actually discovered at this time that because he had the January 4th incident, that he was wearing the exact same clothing when he committed this crime. And that's how they identified Mr. Palmer.
They occurred in reverse order, though.
Yes, that's
okay.
correct.
All right.
And that concludes the factual basis, Your Honor. If anything that the state would have to add, both victims in both cases were homeless individuals. All the officers that I spoke to in regards to this case believe that this was a mental health situation. Didn't believe they were the most violent incidents, despite the "I'm going to blow your head off" remark, and that the state believes that this is a good negotiated resolution because it does monitor Mr. Palmer. And I'm aware that Your Honor is familiar with him before. He did use his first offender in a 2018 case, I believe. I had that case number with me. I apologize for not having it. Regardless, we believe this is a good negotiated resolution and would ask that Your Honor accept it.
Okay. Ms. Jackson, almost done for the day. What do you have for Mr. Palmer's criminal history?
Excuse me, Judge. The defendant has 19 cycles. The defendant's last arrest was December 4th, 2021, with the City of Atlanta Police Department for criminal trespassing. There was no disposition for that arrest. The defendant does have, I see, 2 felony sentences. He received first offender treatment in 2013 with theft by receiving stolen property. And in 2018, he received an Harper plea, first offender for aggravated assault. And the defendant does have misdemeanor convictions. There was one in 2013 out of Cobb County for theft by deception and theft by receiving stolen property. And that was one in 2010 for theft by shoplifting. And the defendant does appear to have a history of failure to appear. There were 2 in 2018, Your Honor. Nothing in addition.
Thank you, Ms. Jackson. You have a great weekend, and I think we've got some calendars next week, so we'll see you then.
Thank you. You as well, Your Honor.
Take care. Ms. Tucson, is Mr. Palmer, it doesn't sound like he would be, but is he on probation for anything right now?
No, Judge, it ended last year. I did put it in the chat because he said he didn't have the case number. So I just wanted to put it in there, but it ended February 20th of 2022.
Okay, thank you. Mr. Adams, what do you want to tell me about Mr. Palmer and these cases?
As you know, he's had a rough past, but he seemed to turn his life around. He's, I think it's AQC Traffic Control Company. He was working on the highways. He directs the traffic and all. He's been there for 4 months, I believe. I talked to his mother. He seems to be doing well. He's cleaning up his drug problem and all. We think, as the state stated, we think it's appropriate resolution.
All right. Mr. Palmer, how you been since I last saw you?
I've been better.
Been better. You were at, I'm not going to remember the name of the place, a restaurant. You worked at a restaurant for a long time.
It was the old lady gang.
Old lady gang. That's right. What happened with that?
Due to the pandemic, they shut down. And afterwards, I returned, and the income wasn't matching. Then, after that, I lost my place. Then I found another job working at the federal building right here as a line cook. I worked there for a long time, for a little bit, probably like 4 or 5 months, due to the location of Douglasville in Atlanta. That didn't work out.
Douglasville is where you were living?
Yeah, I was currently residing there, back and forth, trying to tussle the job and transportation
Sure.
at the same time. So then that didn't work out because I wasn't able to be on time as much as possible. And then I was staying in MLK by H.E. Holmes train station, and I paying my rent, and then I was working at Metro PCS for a little bit, and then money wasn't adding up to how much my rent was, so that kind of threw me off track a little bit. And I was still trying to be in touch with mom and still trying to do it on my own and still use my resources. And
right,
situations happen, the elements happen, and I'm accountable for my actions.
Sure. Where are you living now?
Right now, I'm at 3380 Thorn Ridge Trail in Douglasville, Georgia, with my mother.
You're with your mom.
Yeah.
Okay. She'll let you stay there for a little bit?
Of course. Yes, most definitely. I have a good relationship with my mother and my brothers.
Who else lives in the house?
Just me, my mom, my brother.
Are your brothers grown or are they students?
Yeah, my brother's grown. He's 30.
Okay. Does he work?
Yeah, of course.
What does he do?
All right, and he's a forklift operator. I believe out of a company called
Either way, he's a forklift guy.
Yeah, he's a forklift
Okay.
guy.
So he's a little younger than you are.
Yes, sir.
Does your mom work?
Yes, sir.
What does she do?
I think she's still in accounting.
Okay, good. And then you've been with this traffic
control out of AQC traffic control out of Austell, Georgia for about 4 months, going on 4 months now. I already received the raise.
How do you get to the sites where you're working?
Oh, actually, we have a location where we dispatch from, which is Austell. We got to be there every morning at 6 a.m.
How do you get to Austell from Douglasville?
I pay a little fee to my brother every week, to take me to.
He drops you off?
Yeah, he drops me off.
Great.
And I will catch a Lyft or Uber back and forth.
Okay, so he gets you to the Austell dispatch, and then they put you guys in a van or whatever it is to get to the site where you're doing the traffic?
We dispatch from the Marietta location, then we work alongside a driver, which we go all across the state of Georgia. Sometimes it could be out of town, but it's only if recommended.
What's the pay right now?
$15.50.
That's great. And that's a raise from what you started at.
Yeah, yes, sir.
And are you getting there on time thanks to your brother?
Yes, sir. And Uber too.
And Uber. Sometimes you pay more. Which is cheaper, your brother or Uber?
My brother.
Your brother. Okay, good. So you were able to afford an attorney like Mr. Adams because you're making some money and your mom helped out, or how were you able to retain?
By me, I had income tax and I had stimulus combined, and that money was accumulating in my Wells Fargo account.
Yep.
So we was trying to get the power of attorney working out. So my mom was just like, you know what? I'll just pay it, and then once you get out of jail, you just reimburse me.
Okay.
I just end up reimbursing me.
Got it. How long were you in jail?
Approximately January 4th to July 27th.
Oof. Okay. So for a few months, and you've been working pretty much since then.
Yes, sir.
All right. Do you have any questions about what we discussed?
Oh, no, sir. Only one question is, I spoke to A&R ankle monitoring business. They said once the case is resolved and handled, then proper paperwork should be given or faxed over to them so they can remove this ankle monitor.
Right. They'll want to do that because they'll want to get it back. You'll want to get it off. I don't know how that process works, but Mr. Adams can help you navigate that. It should be A&A, ankle monitoring.
I'm sorry.
Yeah, that's our standard provider, and they'll know what to do. So you can even call them after today saying, I pled guilty, I've resolved my cases. And they'll say specifically, we need the final disposition, whatever it is they need. They're papers that Mr. Adams can get once I sign them and file them, and he can get them to you, or you could give him the email address wherever they need to go. But start with Mr. Adams to see how he can connect with them to get them what they need.
Yes, sir.
That's what you paid him for. All right. Mr. Palmer, I find there's a factual basis for both your pleas and that your pleas are knowing and voluntary. I'm going to sentence you pursuant to the Probation Options Management Act All that means is that while you're on probation, if you have a small violation, you and probation can work that out. I don't need to get in the middle of it. But if you get arrested again for something, especially something like this, where you may be taking things that belong to other people, that will come back to me and we'll work through what the consequences might be for your probation. Mr. Palmer, do you authorize my staff to sign the 2 indictments on your behalf indicating the guilty, please?
Yes, sir.
Mr. Adams?
Yes, sir.
Mr. Jordan?
Yes, Your Honor.
All right. Mr. Palmer, on the case ending in 581, which has the robbery allegation in it, where Mr. Powell was the victim and you took his backpack at Lindbergh MARTA station, I'm sentencing you to 5 years. Those years will be probated. It sounds like with your current work and your current way of getting around, you don't need to be on MARTA trains. Is that a fair statement?
Yes, sir.
Okay. Number one, you'll need to stay away from the Lindbergh MARTA station. It will also be a condition of your probation that you don't take MARTA trains. You may take a MARTA bus because at some point you may need to get from A to B, and you could do that on a bus, but no MARTA trains while you're on probation. If your work changes and you suddenly need to be riding the train for work, let Mr. Adams know, and I'll think about modifying your sentence so that you could ride the trains for work. But for now, I'm anxious to keep you away from the folks you got to know or didn't get to know, but didn't get along with, who were at either the Lindbergh station or that address you shared, Mr. Jordan, for the January case with Ms. Villa is the Peachtree Center MARTA station. So no MARTA trains. I'm going to have you submit to a mental health evaluation. That's not going to be something new and you're not going to learn something new. I know you and I have already had discussions about some of the things you're working through, but I want to make sure you are getting adequate treatment, whether that's counseling or if there's medication that will help you work out some of the ups and downs. When we were working together in drug court, it was my observation that your issue that was holding you back the most from some of your aspirations wasn't so much using drugs as it was making sure that your mental health was okay. And instead of you engaging in self-medication or anything like that, I'd like it to be under the medical supervision of a doctor. So that'll be a condition of your probation. No contact with Mr. Powell. And I'm going to ask that probation assign to you a mental health probation officer, which just means it's someone attuned to some of the things you've worked through in the past. And so that person will be better able to adapt if you have something going on that's causing you maybe to have some erratic behavior. Instead of the probation officer saying, "Oh, we got to go arrest Palmer," it would be, no, let's connect him with some resources so that we can do it in a way that doesn't turn your life upside down and you wind up in Rice Street for another 6 months. Okay. Does that make sense?
Yes, sir. It makes a lot of sense.
All right. In your other case, 22 SC 184637, which is now just a misdemeanor, I am going to give you a 12-month suspended sentence. I'm not going to put you on probation there because it's actually a separate probation office. You'd have to pay a separate fee and you'd have 2 different supervisions. It'd only be for 12 months. So that's 12 months suspended. It will run concurrently with your sentence in the case ending in 581. That is how we're going to work through all those pieces. Mr. Jordan, anything else on behalf of the state?
Nothing further from the state.
Mr. Adams, any questions about any of that?
No, y'all.
Ms. Tucson, can you please give Mr. Palmer his reporting instructions? It sounds like his address is in Douglas County.
Sure, no problem. That's my old office.
All right. I bet they miss you.
They do. Mr. Palmer, I saw that your address was in Douglasville. Do you have a phone number I can call you?
Yes, it's 470-560-1016.
1016. What's your address?
3380 Thorner Ridge Trail, abbreviation TRL, Douglasville, Georgia 30135.
What's the first word of the street?
Right, I didn't understand that. 3380.
Thorn, Thorn.
Yes.
Got it.
IDGE.
Yep, Thorn.
Or it'd be Thorn, that's Thorn
Yeah.
Ridge. The
Yeah.
is kind of southern, I guess.
Yeah, that's fine.
So-
Thorn Ridge.
Do you know where probation is in Douglasville?
No, not at all.
Do you know
Only
where, well, I'll call you and give it to you. Do you know where the defects office is and Chick-fil-A and the Walgreens, right on
Yeah.
the, right off of Fairburn
Right.
Road? Yeah,
Yeah.
it's right over there. So I'll call you and give you, you're gonna need to report on April 3rd, okay, at 9 a.m.?
April 3rd.
Yes.
Okay.
But she'll call you, but you don't want to miss that first reporting date because all they do is then say, dang, we need a warrant for Mr. Palmer. And again, you've got a good job right now. You got a raise, you got stable housing. It sounds like the family situation is going all right. So let's create as few hiccups in life as possible. So April 3rd, 9 a.m., but Ms. Toussaint's going to call you, give you that again when you're in a position to write it down, and you will take it from there. Anything else, Mr. Jordan?
No,
Mr. Adams?
No, yeah.
Mr. Palmer, good luck with all that. It's good to see you again. I hope if I see you again, it's because you are telling me which way to go at a complicated intersection and not because you're in here, okay?
Yeah, most definitely, sir.
All right. Thank you, everyone. Thank you, Ms. Toussaint, Ms. Rivers. Appreciate it.
All right, no problem. Have a good one.